Hi, if you're just joining us if you're one of the registered speakers who's just joining us, we've had some audio issues, and you may, if you're not getting audio, you may need to dial in. If you've done that, please also remember to mute any other devices that might also be on audio so we don't get any feedback.
All right, are we ready to begin?
Feedback, Tony. You have two devices?
I don't.
Okay.
Are you still getting feedback?
No, I'm just sending out in the group chat. I am sending out the dial-in number as well as the meeting ID and password for anyone who's having trouble connecting via audio. You can either call in on a phone, and I've given you, if you look in the group chat box, I've given you the phone number, the meeting ID, and the password. You can, some other committee members have had better luck leaving the meeting and signing in again. And we're able to get connected via computer audio by doing that.
Folks, if you're not talking, I'm going to suggest you mute your mics. A lot of this background noise will go away if everybody mutes their mics.
All right, I think we're ready to begin. So good morning, everyone, and I appreciate everyone's patience. As you can see, we are all in new territory, not just today, but certainly during this COVID and pandemic crisis. So we appreciate your willingness to join this meeting via electronic means as we're doing today. We're all going to have to be patient because I think we may all, I've had my own technical problems and we all may face some today. So we're just going to have to exercise extreme patience as we get through this process today. So my name is Tony Romanucci. I'm current chair of the Illinois Supreme Court Rules Committee, and we're about to begin. We're going to do our best to very strictly enforce the time limitations here. Not only are we getting a late start, but we have a very full agenda today. We have 8 items that we have to get through during the public hearing. I believe we have 18 or 19 speakers. We're allotting you each 10 minutes. Please use your 10 minutes wisely. You don't have to use all of your time if you don't need to. I'm not encouraging you to use less time, but if you don't need to, that's okay too. So we've got a long day. We're going to try and power through this and get through this without a break. Having said that, if anybody at any time needs a break for any reason, either raise your hand electronically or raise your hand so that we can see you, or send a chat, and we will take a break. Other than that, the plan is to try and get through this without. So without anything else, unless anybody has anything else that they want to add from the committee or Amy before we start, we're going to begin with our first speaker on proposal 1914. So it's just a little bit out of order, and that is the Honorable Robert Mclaren. If you are on the Zoom, Judge Mclaren, are you available? Judge Robert Mclaren, are you able to hear me?
I believe he's having issues with his sound, possibly.
Do you see any video of him, Amy?
It's blank. It's dark. I see that he's on. Someone just.
He's on. Okay.
Justice Mclaren, are you on? I see him here listed. I don't see audio or video.
You know, if he's having a hard time, it might be easier to just call in with a phone and not worry about the video end of it. Just pick up a regular phone.
Well, what I'd like to do is maybe while Amy is connecting with His Honor, why don't we move on to the next proposal and the first speaker on 1903, on proposal 1903. And then as soon as we get Judge Mclaren on, we can fit him in, either in between speakers or in between the proposal. So, Roy Drips, are you on?
I am.
Okay, Roy, are you ready to begin?
I am.
Okay, thank you very much, Roy. The floor is yours.
Chairman Romanucci and members of the Rules Committee, I'm Roy Drips, and I'd like to thank you for allowing me to testify concerning proposed amendment 19-03. I wrote to identify for the committee's attention potential issues concerning the use of depositions at trial in specific situations, and proposed certain changes to Supreme Court Rule 212 in light of amendments to other Supreme Court rules, as well as changes in the Federal Rules of Civil Procedure. These changes had created potential problems with the present language of Supreme Court Rule 212. The purpose of the amendment is to allow attorneys to predict accurately whether a particular deposition taken in the same case but in a different court will be admissible at trial. Differences in the ability to enforce trial subpoenas outside of the jurisdiction, and differences in the definition of unavailable in Illinois is to allow in Illinois and in federal courts makes drafting a workable rule sort of like fitting a square peg into a round hole. With regard to cases previously filed in Illinois, dismissed and refiled in Illinois, the requirement in present Rule 212D that the depositions be duly filed in the prior action is anachronistic. Rule 207B1 no longer authorizes filing depositions. Rule 207B2 forbids routine filing of depositions. But Rule 212D still requires that a deposition be duly filed in the original action before it may be used in the refiled matter. Although this requirement might be regarded as vestigial, the Supreme Court reminded us in Bright v. Dickey that the rules are to be enforced as written. Eliminating the duly filed language from Supreme Court Rule 212D would conform the rule to the current versions of Rules 207B1 and B2. In a situation where depositions are taken in federal court after removal from an Illinois state court, but are to be used in a state court trial after remand, a similar problem is created. As in Illinois, depositions are rarely, if ever, duly filed in federal court before trial because Federal Rule 5D1 says they must not be filed until they are used in the proceeding or the court orders filing. Because the deposition would not normally be used in the proceeding until trial, and because a remand order would normally be entered well in advance of trial, and because it's very rare for a judge to order a deposition to be filed, the vast majority of depositions would never be duly filed in the federal proceeding before a remand. So Rule 212D would almost always preclude the use of depositions taken in federal court. The other potential problem with the rule is that it doesn't answer the question whether a deposition taken in federal court or the court of another state is to be treated as an evidence or a discovery deposition under the Illinois rules. As a practical matter, this means that attorneys cannot predict with any accuracy before a ruling by the trial judge whether a deposition taken in federal court prior to remand will be admissible at trial. And one of the things I hope to avoid with the amendment is to confront a trial judge with a last-minute decision about granting a continuance in order to take the evidence deposition of a witness or forcing the parties to proceed to trial without testimony that might be crucial. Rule 212A addresses the circumstances in which it doesn't matter whether the deposition is evidence or discovery. Impeachment, an admission, exception to the hearsay rule, an affidavit, or because the witness is dead or infirm. But in other circumstances, whether the deposition is discovery or evidence matters very much. Both Illinois and the federal rules authorize use at trial of a deposition if the witness is unavailable. But the Supreme Court rules define a witness's unavailability differently than do the federal rules. Rule 212B2 generally allows use of an evidence deposition if the deponent is out of the county. Rule 212B3 allows use of an evidence deposition if you haven't been able to procure the attendance of the witness with reasonable diligence in the service of a subpoena. And Rule 212B presumes that physicians and surgeons are unavailable for trial. The unavailability provision of Federal Rule 32A4 has some important differences. Rule 32A4 authorizes interstate service of a trial subpoena if the witness is within 100 miles of the federal courthouse. So, for example, a deposition of a witness in St. Louis could not be used at trial in federal court in East St. Louis, but the same witness could be validly produced in court by subpoena, and therefore is not practically unavailable. But an Illinois civil trial subpoena is ineffective if served out of state. So the same witness whose trial testimony could have been procured by subpoena is now unavailable to testify at trial in an Illinois court as a practical matter, but would be deemed available by the federal courts. And physicians are not deemed automatically unavailable under the federal rules. So this brings into focus the difference in the meaning of unavailable for the use of federal and Illinois depositions. The proposed Rule 212E requires the trial court to determine whether the deposition would have been admissible in the jurisdiction in which it was taken. This approach makes the unavailability provisions in Rule 212B inapplicable to depositions sought to be admitted under Rule 212E. And while an Illinois trial subpoena lacks extraterritorial effect, the Interstate Depositions and Discovery Act will authorize issuance of a subpoena for an evidence deposition in most states other than Missouri. Missouri does have procedures by statute and by rule for deposition subpoenas to issue in aid of an action in another state, so parties should be able to obtain an evidence deposition of the witness if the deposition would not be substantively admissible in federal or the other state's court. Finally, a distinction between Illinois actions that have been dismissed and refiled and actions filed in other states and then refiled in Illinois will be beneficial because Illinois is unique in distinguishing between discovery and evidence depositions. A deposition taken in a case originally filed and refiled in Illinois would necessarily be labeled as either discovery or evidence at the time it's taken. That is not so in other states or in the federal courts. With that in mind, I submit that it is time to update Supreme Court Rule 212. Proposed Amendment 19-03 is a neutral proposal that does not favor either plaintiffs or defendants. It splits into two categories: the use of depositions after substitution or refiling, which remain in Rule 212D, and the use of depositions taken in other jurisdictions, which the new Rule 212E addresses. Proposed Rule 212E's provision for pretrial orders to require reasonable notice of intent to use the deposition is important because determination of contested admissibility of a deposition should be made far enough in advance of trial so that an evidence deposition may be taken if the deposition in the other jurisdiction is deemed to be a discovery deposition. That will also avoid preventable continuances. I would just suggest that there is no reason to turn the rule into a trap for the unwary. And thank you for permitting me to address the committee.
Is this an appropriate time for questions by the committee, Mr. Chairman? Chairman Rokuchi, can you hear me?
I can hear you. I was asking a question. I don't know if you could, if you heard mine or not.
Oh, I did not hear yours.
Okay. Mr. Drips, can you hear me?
Yes, sir.
Okay. So my question was that you are proposing an entire new subparagraph under 212, and that's subparagraph E. Is that correct?
Yes, sir.
All right. So just so I want to understand procedurally, subparagraph E, have you tested that paragraph to ensure that there's no conflict with respect to the laws of another state on how their depositions are to be used when you're proposing E?
I'm a little lost about tested. I think the rule says, the proposed rule says that you have to determine whether it would be admissible in the other jurisdiction, which will require the trial judge to make a determination after the proponent of the deposition demonstrates why it would be admissible in the other jurisdiction. I'm not hearing if anybody's talking.
Tony and Mike, you're both talking, but no one can hear you.
Mr. Chairman, have you concluded? If so, I have a question. If not, I will wait. Can't hear.
Hi, is anyone speaking right now? I can't hear Mr.
Yeah.
Romanucci, but it looks like he is talking.
Mr. Drips, can you hear me now?
Yes, sir.
Yeah, I apologize. I don't know why my phone shows I'm not muted, but it keeps telling me I'm muted. So I don't know what is wrong. So I apologize. My last question was, are you familiar with any other states that have a similar proposal as you do in subparagraph E?
No, and the reason for that is I believe now Illinois is the last jurisdiction to maintain a distinction between evidence and discovery depositions. So Almost every other jurisdiction has a rescript of the federal rules for their discovery provisions. There's some that are a little bit different, but for the most part, they follow the federal rules. And this is why I believe that they can be put together in one subparagraph.
Thank you. I have no further questions. Mike, Member Rothstein, I know you had a question.
Morning, Mr. Drips.
Good morning.
Your original proposal, which you submitted in January 2019, proposed language to accomplish this amendment. The proposal that, and we included your proposal in the materials that were circulated, we took an attempt at trying to maintain the spirit, but to simplify the language in proposal 19-03. And I'm curious whether you reviewed the simplified language, and do you have an opinion as to whether or not it captures what you were trying to capture in your original language? And if not, how so?
Okay. First of all, yes, absolutely. I've reviewed it. And my remarks today have been directed to the subcommittee proposal 19-03. I think the subcommittee proposal is a significant improvement on what I submitted. I think it clarifies things and does maintain the spirit of my original proposal, but brings more clarity to it and focuses the trial judge on the task at hand, which is determining what how the deposition would have been used in the other jurisdiction.
And so I'll take that as your fervent support for the amended language as proposed in 1903.
Absolutely. I completely endorse that. And I want to point out that the provision for having the notice provision in case management orders, I think is really a significant step. I think that will allow these issues to be headed off well before trial so that we don't have last minute continuances to go get a late deposition of a witness.
Thank you. I have no further questions.
Any other questions from any member? Thank you, Mr. Drips.
Thank you, Mr. Romanucci.
Mr. Eckler, are you on the call?
I am, sir.
All right, Mr. Eckler, your time is starting now. Thank you so much. You may proceed.
Thank you, Mr. Romanucci, and thank you for the members of the committee for allowing me to be heard today. I'm speaking on behalf of the Illinois Association of Defense Trial Counsel, my capacity as its legislative chair. I'm going to be relatively brief because, as I hope was clear in our statement, it is not in opposition to the proposal that Mr. Drips has made and it has been amended by the subcommittee. It's rather dealing with the issue that Mr. Rothstein asked about regarding notice. The proposal in E is to require reasonable notice of the intent to use the deposition in order to give the trial judge an opportunity to deal with the issue in sufficient time for the parties to prepare, whether it's another discovery deposition, an evidence deposition, subpoena, what have you, in a given situation. It's in addition to the other issues that we've laid forth, and in order to try to move things along out of respect for everyone's time, we could suggest a more specific time be put into the order by which time a party has to propose that they're going to use a deposition taken in another matter at least 60 days before the close of discovery, so that the trial court, opposing party, and everyone can prepare appropriately for that, address the issues, address perhaps whether how the other court, the foreign court, would deal with that issue, whether it's a federal court or a sister state court, and allow the trial judge to get up to speed on that, allow the parties to brief that issue if it requires briefing. But giving the sufficient notice, I think, needs to be made more specific with regards to when that disclosure has to be made. In the current proposal, it's just reasonable, and while reasonable is good, a specific time we think would be better. And with that, I'll yield.
Do you have a specific proposal that you want to recommend?
as we put in our papers, Mr. Romanucci, we would suggest at least 60 days prior to the close of discovery. So that would be at least 120 days prior to trial. Hopefully, if 213 disclosures were done, it would effectively be earlier, so that parties would have an idea, and hopefully the parties would be discussing the issue, but at least 60 days before the close of discovery.
Thank you. Any other questions or comments from any of the committee members?
It's Michael Rothstein. Mr. Eckler, I appreciate the benefit of what you are suggesting with the 60-day period. Would you be comfortable if, in addition to the 60-day period, language was added in the sense of unless the court determines otherwise or absent leave of court, to allow for the possibility that a deposition could come to light in a period less than 60 days, but under the circumstances the court believes it would be fair to all the parties, to use the deposition?
I can imagine a circumstance where that might happen, but it would be in a case where this is a case, as Mr. Dripps pointed out, and the reason for the rule is that this is a case that either been refiled in state court, was refiled from federal court, remanded. It's a case everyone should be familiar with. There shouldn't be surprises. Everybody should know where they're at. I don't know why it would be that all of a sudden we discover a deposition taken in a related case between the parties and it not be known at least 60 days before the close of discovery. We're generally in favor of giving courts discretion to do justice between the parties. And if that's the mood of the committee, we certainly understand. But I think that there shouldn't be surprises here. That's the whole point that I think Mr. Dripps is making.
Thank you.
Anyone else on the committee for any questions? Thank you, Mr. Eckler.
Thank you.
I would like to remind all the participants to please mute your phones if you are not speaking or not anticipating speaking. We pick up background noise and it does interfere. So I would appreciate that, out of respect for those who are speaking, to please have your phone on mute. Amy, are you able to tell us whether or not Justice Mclaren has been able to join?
I'm online.
Get myself. I did speak to Justice Mclaren, and he was going to call in. Are you there, Justice Mclaren?
Yes, I am.
Okay.
Can you hear me?
Yes.
Okay.
Justice Mclaren, this is Tony Romanucci. Sorry we took you out of order. You were having some difficulty. I think that's resolved now. So yes. Justice Mclaren, you'll be presenting. You're the proponent of Proposal 1914, and yield the floor to you, Your Honor.
Thank you. I thought about what might have caused this problem, and I thought that probably what did it was the fact that when the rule was changed in 1983, 303A2 was changed in 1983, so approximately 2 years after the decision in Sears versus Sears, there was no commentary by the committee as to the reason for the change. And I can accept the rationale for that because I think, as the ALA has said in its comments, that it's self-evident. And it doesn't take, I think, even a lawyer, I think a layman or a grammarian would understand what it was supposed to mean. And I interpreted that in a case called Augustin, which was a marriage or a divorce case in the 80s, I believe. And it wasn't until 2019 where a panel that I was on decided that Sears versus Sears remains inviolate, and that, according to their timetable, a motion to reconsider a post-judgment motion must be filed not within 30 days of the denial order of the post-judgment motion, but within 30 days of the final judgment order, which for most jurisdictions or most venues is a practical impossibility. But be that as it may, I think my dissent in Orihim, People v. Orihim, is self-explanatory. And so I would like to spend the time available to discuss the comments made by the Appellate Lawyers Association. And there were 3 points that they made. One was maybe since this is a criminal case, the rules should be amended relative to rules of criminal procedure. And that's all well and good, except that the majority was interpreting 303A2. It wasn't interpreting criminal rules of procedure. And so I think it's kind of a deflection or a misdirection to suggest, as the ALA does, that we should maybe consider changing the rules relating to pleas or the vacation of pleas, et cetera, versus resolving or remediating the ruling or the holding of the majority in Orihim. They then suggest that my proposed language is somewhat ambiguous and possibly confusing. And I can understand why, because I agree with the ALA that what is there is sufficient. It's appropriate. It doesn't need to be changed. But the thing is, what I'm not aware of or certain of is that a rule doesn't have to be amended, but can merely be clarified by a commentary added by the Rules Committee. If the Rules Committee can add a commentary saying that we have considered this and we leave the rule as it is because we believe that it is self-explanatory and that it was an attempt by the Rules Committee back in '83 to amend and ameliorate the conflict between the argument relating to a timely appeal and the ability of a trial court to remediate what it considers to be error. If committee comments can resolve that issue, then I don't see the need for any other language. I proposed the language because I was attempting to address the rather what I personally consider to be highly impractical, if not illogical, that one must file a motion to reconsider a post-judgment motion within 30 days of an order that it doesn't address. It only addresses it tangentially or indirectly by addressing the denial of the post-judgment motion. So I would suggest that if somebody wishes to amend what I've said and say something like, so long as the court retains jurisdiction, I have no problem. But something needs to be done because the rule's been nullified and Sears versus Sears is back on the table. And I also would like to thank the ALA for agreeing with what I perceive the rule to be, which is self-evident. Other than that, I have nothing further to say. Are there any questions?
Does anyone from the committee have any questions for Justice Mclaren? From my understanding, Justice Mclaren, just so we're clear, is that if the committee were to comment with respect to the rule as opposed to amending the rule, that would be satisfactory.
Yes, if it indicated essentially what I said, which is that Orihim was wrongly decided and that trial courts do have the ability, especially since the 4 or 5 cases relating to subject matter jurisdiction, and those being 3, subject matter jurisdiction, personal jurisdiction, and statutory authority granted to trial courts relating to administrative review. Those are the 3 criteria upon which jurisdiction is based. It's not based upon the old jargon that if you're over, say, 65, you may recall, was unauthorized at law is void. That was essentially what Sears said, because they basically said there's no statute or no Supreme Court rule authorizing these post-judgment, successive post-judgment motions, and therefore they said it was unauthorized at law, effectively, and the orders were void. That concept doesn't exist anymore. Does that answer your question?
It does.
Thank you.
Anyone else from the committee with any questions or comments? All right, very well. Thank you, Justice McLaren.
Thank you.
We will now move on to Proposal 1911. Give me one moment, please. And our first speaker on that proposal is the Honorable James Murray. I saw Judge Murray on the line earlier. Judge Murray, are you still there?
Yes, I am. Thank you.
And you may begin.
Thank you. Good morning, members of the Illinois Supreme Court Rules Committee. My name is James C. Murray, Jr. I am a retired judge of the Circuit Court of Cook County. I am now of counsel to my brother's rather small law firm. I think some of you already know that I am related and who influenced me to become a lawyer, my father, who was a respected Circuit Court judge and an appellate court justice. I start out with the Supreme Court Rule 23 was promulgated by the Supreme Court on January 31, 1972. Although over the years there have been slight modifications to the rule, the essence of the rule has remained the same. Interestingly, when I was attempting to find out the rationale behind the adoption of the rule, there was no commentary regarding it. So I reflected back on my own experience and attempted to provide what I thought was the reason the Supreme Court adopted Supreme Court Rule 23. I look back at my career as a lawyer. At the time, and some of you might remember this, opinions from the appellate court that were issued would be issued as advance sheets. These were paperback volumes, and in some way would number anywhere from 200, 300, 400, 500, even 1,000 pages in length. And these types of books would stack up on a lawyer's desk over a period of time. But every lawyer was responsible for basically, in effect, making certain he knew the law and eventually had to drive through and review these advance sheets. Eventually, these advance sheets would be turned into hardcover volumes of our appellate court decisions and then added to a law firm's library. An appellate court, and there was a reason for this rule. Each appellate court judge on a yearly basis had to generate at least 30 written opinions that basically you can only imagine, given the number of appellate court justices, the number of opinions that would emanate on a yearly basis out of our various appellate courts throughout the state. I believe in order to control the number of such opinions that were to be published in the advance sheets and resulted in to being put into hardcover volumes, the Supreme Court adopted Supreme Court Rule 23. Supreme Court Rule 23 currently consists of 3 sections relating to the decisions of the appellate court. My first reason why the rule should be abolished is technology. I do not have to describe to this committee that the practice of law has been radically changed and revolutionized over the last 48 years by technology. Today is a classic example of that the advancement of technology, both in software and computer equipment, have radically changed the landscape of legal research in the profession of law. The advent of such software such as Westlaw and LexisNexis have placed what were contained in law libraries, the corpus of the law. Such software contains not only case law, it contains statutes, regulations, court rules, secondary source materials. These services contain both federal and all the state laws of our country. Today, I can carry on my entire law library on my cell phone. As a result of this advancement in technology, law firms have eliminated their law libraries. There is no need to be concerned by the problem that existed and was confronted by our Supreme Court in 1972. The problem has been resolved by technology. There is no longer any reason why appellate courts of this state should determine whether an opinion from the court should be in the major league of opinions or the minor league of opinions. Supreme Court Rule 23 is an obstacle to the practice of law. Supreme Court Rule 23, a substantial number of the opinions by the appellate court are designated under Rule 23 as orders, so that they cannot be cited to as precedent to either the appellate court or to any other trial court. Rule 23 is used more as a sword when a litigant cites a Rule 23 case. Classic example of that has occurred on June 10th, 2020, in the case of Moselle versus CC Services, Inc., 2020, Illinois Act 2nd, 1990411, paragraph 40. The appellate court, the appellant cited two Rule 23 opinions to support a legal argument. His opponent moved to strike it. The Court of Appeals granted it as being violation of Rule 23. I have been both an attorney and as a judge. As a judge, Cook County, I was responsible for entering judgments of confession for the entire county. In one particular case was moved to vacate the confession of judgment. I denied it, and the matter was taken up. My opinion was taken up to the appellate court. I was affirmed on appeal. Unfortunately, the opinion was affirmed under Rule 23. The case is First Bank versus Kaiser, 2012, Illinois Act 1st, 112505U. If that opinion was published, that would have relieved me of a heavy burden because I handled all the confession of judgments in Cook County. I could have eliminated a lot of unnecessary motion practice as it relates to it. The fact that this rule has deprived lawyers, judges of valuable decisions which could be used by the attorney or the judge, for that matter, to support his or her legal argument or assist in rendering a decision. The rule should be abolished. Supreme Court Rule 23 has problems in its structure. The only cases that Rule 23 determines that are precedential are cases which establish a new rule of law, modifies an existing law, criticizes an existing rule of law, or prevents or resolves or avoids conflicts within the appellate court divisions. Supreme Court Rule 23A, that section rule seems to be that to ignore not only sets out that only the law applies. Well, we all know appellate court decisions contain two aspects, facts and law. And I direct the committee's attention to the Illinois Supreme Court decision in People X Rel Herrick versus 2010 Harley Davidson, 2018 Illinois 121636. It was a civil forfeiture case. And reading the majority's opinion in that case and the dissent in that case, which focused on the facts, you will see how and what manner facts in a particular case are equally important. What about the lawyer who finds a Rule 23 case that has similar facts in his case, but he can't cite it because of the fact that Rule 23 precludes him? Rule 23B is where the vast majority of opinions are emanated out, and they're called Rule 23 orders. And for me, over the years, it has always been difficult for me to determine why a Rule 23 order cannot be cited as precedent, since many of those orders cannot be considered distinguishable from those that are classified as precedent. Rule 23C, entitled Summary Orders. I must admit, I've looked for such orders. I have been unable to find such decisions from an appellate court. I'm just wondering whether or not that meet that standard. My impression is that this section is not used, or if it is used, it's not invoked very often. I want to thank the committee for its consideration of my proposal. I urge the committee to act favorably on it, because I think technology basically eliminates the rationale and reason, and it will open up an entire scope of opinions that should be considered as precedent for the attorneys and judges, even including appellate judges of the state. I don't have to express how technology has radically changed our law. We no longer file paper copies of our briefs, e-filing. Look at this on Zoom, where our Illinois Supreme Court has issued our orders as far as the commencement of our trial to basically consider off-site hearings of the appellate of court. Bond hearings are conducted by Zoom, and I think we should now. Rule 23 should be basically done away with. Technology has eliminated its reason. Thank you very much for listening to me.
Justice Murray, maybe I missed something. I just want to make sure that I have it. You said there are 3 reasons to abolish Rule 23. And you said number 1 is technology. Can you just tell us in the bullet points, what is reason number 2 and reason number 3? I may have missed them.
All right, let me, maybe they're not reasons, but
so
they're
1 is technology, number 2 is what?
Basically, that Supreme Court rule represents an obstacle to the practice of law. What it does do is it deprives lawyers when they're doing their legal research, and this has occurred to me both as a lawyer and as a trial judge, that I've run across Rule 23 opinions that I would like to cite, but I know the rule prohibits it, so I don't do it because the rule prohibits me. So I think basically, in effect, there are other lawyers in this state that are like me, that have come in their legal research, come across Rule 23 opinions that they believe would be favorable to their legal position, but recognize that they can't cite it to a court because of Rule 23.
And what would reason number 3?
The reason for number 3 is I think it had, at least this is my opinion. I don't know whether anyone wants to agree with it, but I think the Supreme Court rule has problems in its structure. If you look at Rule 23A, it basically focuses all attention on the law. That is, it has to generate either new law, represents a change or a modification of the law, avoids conflicts within appellate judicial districts. Primarily, that would be in the first district, where we have 5 divisions. And I remember in practicing law, I ended up with about 2 or 3 cases on discovery that were directly opposite each other. So, I mean, that's an admonishment there, but it doesn't take into consideration that really, in effect, there is a factual component to every case. And if the facts are somewhat unique, then I think that should be included in considering whether or not it rises to a precedential value. And Rule 23B, if you look at that, if you look at the vast majority of Rule 23 cases, there is little to distinguish they represent almost full-blown opinions. So there's little to distinguish those of Rule 23 orders from the actual opinions that are classified as precedential. And Rule 23C, I don't think is used. I mean, you have a rule there that's just not used. At least I haven't seen any cases that use it. And those are my 3 points.
Thank you, Judge. Are there any other questions or comments from committee members?
Can I have can I add one remark, please?
Sure, if it can be brief.
It is very brief. First of all, I want to eliminate a couple of problems. There might be a problem. One, if the committee adopts my rule or position on this, I think it has to make clear in the adoption that it has prospective application. We're not, by virtue of this rule, resurrecting everything that went in the past that fell under the Rule 23 that were not precedential. We're not resurrecting them and considering them presidential. I think that would be a problem. The other thing is that in the modification that I read, it talks about a full opinion. And frankly, I think it could be expressed as a full opinion. The last thing I want to do is impose any further burden on our appellate court justices. And I don't know what full opinion means. If you take a look at Rule 23 opinions, those are full opinions. So I would ask that the deletion of the word as a full out of the proposal 1. It must be expressed in an opinion. Thank you.
Thank you, Your Honor. Our next speaker is William McPhee.
Can I ask a quick question?
Oh, of course. Who is that?
Judge Anderson.
Thank you, Your Honor.
Sorry. Sir, Judge Murray, do you have an opinion on whether Rule 23 prohibits a judge from citing a Rule 23 case? I mean, if you're to be a strict constructionist or a textualist, there's nothing in Rule 23 that prohibits the court from citing a Rule 23 ruling. Would you agree?
Judge, with all due respect, if you take a look at the decisions under Supreme Court Rule 23, I think there's an opinion, if my recollection serves me correct.
There are several, and they're split.
Yeah, well, I'll tell you, I mean, the Supreme Court has criticized judges basically, in effect, citing Supreme Court Rule 23. I think I look to the Supreme Court for my guidance as to what kind of how I should determine my practice. And I rarely, I've never used a Rule 23 opinion. I think it's a violation of the rule. It applies to both lawyers and judges.
If there's a Supreme Court ruling on this, I'd sure appreciate it if you sent it to me. There may be, but I've never seen it.
Would you do me a favor, Judge? I'd appreciate it if you would. I think Amy has my email address, if we email it so I could basically get back to you on it.
I will do that. And I don't want to take up any more time. I would just point out for the record, though, that there are appellate court cases that go both ways on this. I'm not aware of a Supreme Court case. Thank you, Mr. Chairman.
Thank you. Any other questions or comments before we move on to Mr. McVisk? All right, Mr. McVisk, the floor is yours. Thank you.
Thank you, and I hope everybody can hear me. I'm using my speakerphone. If there's a problem, please let me know.
Hear you fine.
Great, okay. And I am the immediate past president of the Illinois Defense Council. Illinois Defense Council, as most of you know, is an organization made up of people, civil litigators who represent defendants and their insurance companies. We basically agree with almost everything Judge Murray just said. I think we need to eliminate Rule 23, so I'm going to keep my comments brief. As Judge Murray said, there's no need for this rule anymore with digital case law. It was one thing when the expense of printing volumes was huge, the expense of purchasing libraries was huge. That's not such a big deal anymore. And I guess what I would talk about is the practical impact that this has had on litigators. I can't tell you, I think courts would be surprised, given the number of Rule 23 opinions or decisions I see, I think courts would be surprised at how often something that they have decided really does actually break new ground, even if it's with respect to the application of facts. Most of my practice, or a big, huge part of my practice, is insurance coverage. And in insurance coverage cases, the thing that is the most important in 90% of the cases is the application of specific policy provisions. I can't tell you how often I have found in my research a Rule 23 decision, which is the only decision that is on point interpreting the policy language that I've got. Now, if I can't cite that, that means that I can't use that for the judge, and I basically, it's a meaningless decision, despite the fact that often, as Judge Murray said, these Rule 23 orders are very well written, they are well thought out, and they are, sometimes they hurt me, sometimes they help me, but at least I know which way I'm going to go. But with the Rule 23 being the way it is, we can't rely on them. So I think both insurers and insureds need to be able to know how an appellate court has interpreted this rule and be able to cite that in the case in the future. Up until now, this has just not been the case, and I can tell you, I've had a couple of cases that I've been on where an appellate court granted a decision either in my favor or against me on a Rule 23 order, and then we've moved to have it published, and that's been great. Usually the courts are pretty receptive to that, if you can explain why it is that the court needs to be published. But I think relying on the litigants to make a motion to publish the case, that's probably not the best thing either, because sometimes litigants don't want that result published. So they're not going to make a motion, especially when you lose the case. You're not going to have something published. Insurance companies often don't want even a win published because then it's going to be used against them. But I think it is fair if they are published. One thing I would also add is just I agree with Judge Murray's comment that it probably needs to be done prospectively. We recognize that a lot of the opinions that or Rule 23 orders in the past may have been written differently if the court was aware that they were going to be precedent. And I think given that, it would be not appropriate to have them be citable by litigants prior to the time the rule changes. If the court is making its decision being aware that its rule will be cited, I think it may write its opinion somewhat differently. And I think that is something that has to be borne in mind by the committee. We have offered, some members of our task force that were looking at this thought that there might be some utility to Rule 23 insofar as maybe some decisions should not be precedential, but we all agreed that even non-precedential opinions ought to be able to be cited just like you would cite the law of a foreign jurisdiction as persuasive authority. My personal opinion is I think that we should just do away with Rule 23 altogether, and all decisions should be something we can cite. Thank you. Those are all the remarks that I had.
Thank you, Mr. McFist. Any questions from any members? All right, hearing none. Our next speaker on the same proposal is individual Clint Chrisloff. Mr. Chrisloff, are you on?
I am. Can you hear me?
We can. I can hear you at least.
Terrific. Okay. I have my phone and my computer on, and I'm hearing you on one side and speaking on the other. Thank you, Mr. Romanushian. Thank you, the committee. I come from the other side of the aisle. We are a almost always plaintiff's firm doing class actions and public interest cases. And I can tell you that our experience over my 45 years of practice is we have had to deal with Rule 23 again and again and again in every different combination, permutation you can imagine. The fact is, as the justice noted, the rule's purpose has become obsolete. Although you've got some books behind me, the fact is most of the case reporter decision books have been gotten rid of. And the fact is, you can cite anything as persuasive authority. You can cite the aphorisms of Miss Piggy and Kermit, and you can cite Bob Dylan. Bob Dylan, there's in our submission, we've cited a number of situations where either the courts or the parties cite Miss Piggy, Kermit, Bob Dylan, Bruce Springsteen, you name it, because they are persuasive authority, because they do ring true in people's minds to support the proposition that's being offered. And if you can cite Sesame Street, the idea that you are prohibited from citing the hopefully thoughtful opinion of learned justices, that you're barred from citing them, makes no sense whatsoever. And indeed, although we struggled through this in the federal courts, the federal rule of appellate procedure 32.1 threw out this concept that there's anything that you can't cite. You may have to provide a copy of it. You may have to provide the basis that you're quoting. That's fine. And that's what persuasive authority is all about. The fact is, the rule has always been ridiculously or unevenly applied. We have a retiree healthcare case that's been going on for 30 years. We were apprised of a case downstate where a district downstate had rendered an appellate decision that was a Rule 23 order. We had to move to intervene in that case, to move to have it published, and indeed it was then published. But the problem, the amazing thing about it is, and so now I'm cited as one of the attorneys in the case. If you go to look up Dell versus the city of Streeter. But the fact is that parties cite unpublished rulings, and in a couple of the comments that have been made, questions, does it apply to judges? Well, if you go to Byrne against Hayes Beer Distributors, the 2018 Illinois Appellate 172612, you see the colloquy between my friends, Justice Hyman and Justice Mason, over whether the rule should continue and whether it applies to judges. Now, if you can have a judge citing an unpublished order, where does it come from? The judge pulls it out of the blue and nobody addresses it in the briefs. That doesn't make any sense either. The other thing that is very bad about the rule is that it suggests something that cases are put into two tracks. The ones that we care about and the ones that are perceived as justices devoting significant attention to them, and all the rest of them. And the fact is, the combination of people's perception of our system is based on what the justices do. And so if it is perceived that my case has been sent to, it's before a panel, that these days getting oral argument is rather challenging, and then you get a decision which can't be cited by anybody, the perception is that there is a two-track system, and justices really don't care about these. And that's a disservice, because people should not perceive that their cases have been regarded as less than worthy of attention, less than who knows who actually dealt with them. And the justices don't get a pass on this. The comments that the only decisions that should be now citable are those rendered after the rule changes. We don't agree with that at all. The fact of the matter is, this is a part of the Illinois justice system. These decisions have been made in the past. We would support the order to digitize all the old Rule 23 orders for whatever purpose can be made of them, even if they are just to show that there's been a whole series of bad decisions on some area of the law, because the bad decisions eventually lead us, hopefully, to get to the right decisions. This has all been thrashed out on the federal level, and the federal Rules of Appellate Procedure 32.1 provide absolutely fine guidance. You can cite whatever you want to cite for whatever persuasive authority you think it has, and the court may agree or not, but that's how the system should work. We don't give the justices a pass any more than we give the lawyers a pass on doing a slipshod job on occasion. We all err, but the fact is that all the cases should be made public and should be accessible. Why not? I can go into all of the facts, that the different situations where this has occurred, but I think the fact is, hearkening back to the first speaker who talked about Illinois being the last state to keep this distinction between discovery and evidence depositions, there is enough with the mother may I's for any number of things. The idea is to have the practice of law and the rendering of decisions be fair, be open, be essentially uniform, coming up with a bunch of local things that make us a very unique jurisdiction that's less efficient, is not good. And it's not good for the perception of justice. I really don't care, I suppose, about most of Rule 23, because the only one that really affects us all, and the one that brings this on, is 23E, the effective orders that you can't cite, that somebody can't cite them. At the very least, we should get rid of 23E. The rest of the rule, I don't know whether we care or not, but the fact is that the next thing should be that we do digitize all the past decisions so that we can see what the law of Illinois has been. It is not secret. This is public, and transparency is an important aspect, an important guide for justices to do in the future as well. I'm happy to answer any questions.
Any member of the committee have a question or comment for Mr. Chrisloff?
Thank you.
Thank you, Mr. Appreciate your time. Next speaker on the same proposal is Donald Ramsell. Are you on the line, Mr. Ramsell?
Yes, I am. And I'd like to thank the committee for being given this opportunity to speak. I am the author of the Illinois DUI Law and Practice Guidebook. So I spend a great amount of time dealing with the bill and reviewing Rule 23 decisions as well as published decisions. To put it bluntly, an opinion worth writing is an opinion worth citing. And Rule 23 should be repealed.
Mr. Ramsell, I'm going to stop you for just one moment. Please mute your phones, anyone. If you're not speaking, please mute your phones. I apologize. Go ahead.
No problem. So I know that one of the concerns with appellate justices, as I've spoken to them about this rule before, is that they are worried that they would add additional work and they'd have to write a different opinion. But having read many Rule 23 decisions, I've certainly been involved with more than 50 appeals myself across 35 years. I think that the judges take their work seriously and they make every effort to ensure that the outcome is fair, that the decisions are logical, and that they do follow precedent. So I don't think they need to change the manner in which they handle a case in writing an opinion. Certainly, any opinion can be limited to its facts. It can be noted to be fact specific. Justices can certainly recognize that the opinion they write, without declaring it unpublished, as we used to say, is of a very limited value or very narrowly to be construed. This is all a process that can be used by the justices when they write an opinion. There are many times, especially in my world, I handle what would be considered smaller cases where people may be paying $1,500 for a DUI case. We appeal most of our cases pro bono because there are issues that we feel will likely occur in the future. And we spend a great amount of time on a very small case to take it up on appeal, devoting tens and perhaps even 100 hours of work to obtain an opinion at our cost, only to have it issued as a Rule 23 order of no value for anyone. Many of our cases involve suspensions where the length of the suspension for the driver's license is 6 months or 12 months. By the time we get the decision, that suspension has already run its course. Its only value is for the future. Yet we will get a Rule 23 order. We file motions to publish frequently that are denied. And I frankly am at a loss for some of the reasons that are offered. We have had cases where they have dealt with issues of first impression that suddenly become a Rule 23. It is very difficult to sit in a law office and have a client come into our office with a problem where we will tell them there is an appellate decision right on point that favors you, but guess what? We cannot use it. Someone else's effort of 1 to 2 years is worthless to the next client that walks into the office for really no reason. And the public, I think, sees this as almost a body of secret law before we had the internet. There's a very great article that's called "Are Some Words Better Left Unpublished?" A law review article from the Journal of Appellate Practice and Process, Volume 3, Issue 1, that was written in 2001 after a decision of a federal court in Anastasoff versus United States held that unpublished opinions not being able to be cited as precedent was an unconstitutional rule. Although that opinion was vacated as moot, the decision itself is very informative and this law review article is very informative. Obviously, we no longer worry about the cost of the publication. So the reasoning for the two basic reasons for Rule 23, one being cost, is now irrelevant. The second being that the opinions would have to be written with greater attention to detail. It would add work to an appellate justice already overworked or with a large caseload. If you read these Rule 23 orders, frankly, they are just as good and are as well written, in my opinion, as the published orders are. And Illinois is in the minority insofar as having a rule where not only is the decision not precedential, but it is also not persuasive and not to be cited whatsoever. There is a hybrid rule that is more often used where these cases can be cited as persuasive only. We don't even follow that. I would suggest that Rule 23 has the effect of discouraging lawyers such as myself or those with public interest from pursuing appeals on something that does matter, because you can do all that work and receive a Rule 23 order. In my opinion, the basis for Rule 23, which was primarily cost saving, no longer exists. You can still use, and frequently there are summary orders where cases can be remanded for without jurisdiction. There's no reason why we can't continue to use summary orders in appellate courts, but the idea that we cannot cite to a fully briefed, fully litigated case that meant something to somebody makes no sense. Finally, motions to publish. Motions to publish are not always granted or denied, in my opinion, for the reasons that they should be granted or denied. Many parties, as mentioned by a previous speaker, many parties choose not to seek to file a motion to publish, and there's no access. No one else is allowed to ask that an opinion be published, even though it may be of great interest to other attorneys. That's a problem with the motion to publish. And frankly, limiting the motions to publish only to the parties who have already received whatever relief they seek, they're the least likely to be interested in seeking to have it published, other than ego. Because they either won or they lost and it's over for them. Their parties have actually gained whatever relief they sought or obtained. So for those reasons, I would ask that Rule 23 be repealed. It violates and is contrary to the rule of stare decisis, which worked for well over 100 years without difficulty prior to the 1970s, when appellate courts started to employ the concept of unpublished opinions. Thank you.
Thank you, Mr. Ramsell. Anybody have any questions or comments? Thank you. Next, we will move on to Proposal 1901. And we have the proponent of that Rule 1 speaker, and that is Bennett Crawford. Are you on the line?
I am.
Thank you. And the floor is yours.
Thank you very much for having me. My name is Bennett Crawford, and I am the director of the Children and Families Practice Group at Legal Aid Chicago. Legal Aid Chicago represents survivors of domestic violence in court proceedings throughout Cook County. We were joined by a multitude of other legal aid organizations and domestic violence organizations in proposing that Rule 7.3 of the Illinois Rules of Professional Conduct be amended to bar attorneys from soliciting respondents in protective order cases prior to their being served with summonses. Currently, Rule 7.3 regulates solicitation letters sent to a prospective client, but the rule does not address any risk of harm that such a letter may cause to a prospective adverse party. In 2018, we discovered that at least one law firm had been sending solicitation letters routinely to respondents in order of protection cases. We believe this practice continues, having seen a letter as recently as late 2019. Some solicitation letters arrived at the respondent's home before they were served with the petition for order of protection. And in at least one of our cases, the respondent was still living with the petitioner when the solicitation letter arrived in the mail. Sending solicitation letters to respondents in order of protection cases before they have been served with summons creates a high risk of harm to petitioners and undercuts the very purpose of allowing a party to seek an ex parte court order. The most dangerous time for survivors of domestic violence is when they leave the relationship. According to the National Domestic Violence Hotline, 75% of all serious injuries in abusive relationships occur when the survivor ends the relationship. In 2000, the Chicago Women's Health Risk Study found that in 45% of the homicides in which a man killed a woman, an immediate precipitating factor of the fatal incident was the woman leaving or trying to leave the relationship. That same study found that among women who tried to leave their abusers, 69% suffered severe abuse since the attempted departure. The Illinois Domestic Violence Act and other laws which allow for protective orders permit petitioners to obtain those emergency protective orders ex parte if they fear that prior notice would put them in danger. Thus, every ex parte emergency protective order is premised on a judicial finding that prior notice would put the petitioner in danger. However, the enforcement of such ex parte orders does not begin until the respondent is served. A respondent can only be arrested for violating the order after having actual knowledge of its contents. Therefore, the time between obtaining an emergency order of protection and service upon the respondent is a particularly vulnerable time for petitioners. They have taken the step of separating and seeking legal protection from their abusers, but they do not yet have the ability to enforce the order. Because a judge only enters an emergency protective order ex parte after a finding that prior notice of the court proceeding would put petitioner at a great risk of harm, attorneys should be prohibited from circumventing that judicial finding. This proposed rule change, barring attorneys from soliciting respondents in protective order cases prior to service of summons, is narrowly tailored to bar solicitation for a very short period of time. The Illinois Domestic Violence Act and similar protective order statutes provide for expedited service of summons. Specifically, those statutes mandate that these summons take precedence over other summons and must be served at the earliest possible time. This proposed rule change, therefore, appropriately balances the need to keep survivors safe against private attorneys' interest in soliciting business and respondents' interest in obtaining an attorney. I would like to note that passage of Public Act 101-0255, amending the Illinois Domestic Violence Act, Stalking No Contact Order Act, and Civil No Contact Order Act to keep emergency protective orders out of the public record until after service on respondent does not in any way diminish the need for this rule change. That act curbs the actions of clerks and other court officials by prohibiting them from releasing court records prior to service of summons. Protective order court proceedings, however, remain open to the public. Nothing in the act prevents attorneys or their employees from systematically observing court proceedings where these emergency proceedings are held and using the information gained to solicit respondents. Emergency protective orders are a necessary and critical tool meant to protect petitioners who have made the decision to separate from their abusers under extraordinary risk to their physical safety. Amending Rule 7.3 of the Illinois Rules of Professional Conduct to bar solicitation of respondents prior to service safeguards that protection. Thank you.
Thank you, Ms. Crawford. Does anyone on the committee have any questions or comments for Ms. Crawford? I just want to confirm one thing, Ms. Crawford. I believe that when this went to committee, there was a recommendation for a comment. You have no issue with the comment. Is that correct?
That is correct.
Okay. Anything else from anyone? Thank you, Ms. Crawford.
Thank you.
Next, we move on to proposal 1905. And the proponent of that proposal is Mr. Eaton. Are you on the phone, Mr. Eaton?
Yes, I am, Mr. Chair. Thank you.
You may proceed.
Thank you. And I would just begin by making a quick comment because I know you've heard a number of comments to Rule 23. There was a letter which we sent to the Supreme Court several years ago, which was signed by Mike Reagan and myself on behalf of the special committee that was comprised of the ISBA, CBA, representatives of the IJA and the Appellate Lawyers Association, proposing a modification to Rule 23, and I believe it was submitted to this committee recently as an alternative to consider. And I won't discuss that any further other than to say we prepared a report, looked at other jurisdictions, and I certainly support the revision or modification as we set forth in that letter. Would be happy to answer any questions on that as well. The other proposals I have, considering what's been presented so far, are somewhat mundane, but I'll proceed anyway because I think they'll be helpful to appellate practitioners. And this comes from the Chicago Bar Association's Committee on Appellate Practice, which is comprised of all past presidents of the Appellate Lawyers Association, not all, but most. And these are common issues or problems that they run into in practice. And we would just like to have the rules modified to improve appellate practice with these modifications. First one deals with 306, which, as the committee knows, are interlocutory appeals which are filed by permission. So you file a petition with a supporting record. And if the petition is granted by the appellate court, you can supplement the record or the court can order the entire record. And the modification we're asking is that the party can request the clerk to prepare the entire record. Right now, that's not done, and the clerk's office does not believe they have the authority where a party requests the entire record, and that just makes sense because the court should have the entire record whether they order it or not, and it's much simpler. We pay for it ultimately, so we think that modification makes sense. 315, when someone has found a petition for leave to appeal, the time period for running is from the decision of the appellate court or the denial of a petition for rehearing, and 35 days runs from that point. Sometimes the appellate court files a corrected opinion after the initial opinion, and the question comes up, does that also toll the time to file a petition for leave to appeal? The clerk's office says no, and I think they're right, and I know I get a lot of questions on this issue, and we're just making it clear in the rule that if all the appellate court is doing is filing a corrected opinion where there's been no petition for rehearing, that does not toll the time for filing a petition. So that's just a clarification, which we think is important. It does arise more often than you would think, and we want to encourage the appellate court to file corrected opinions, but that has no impact on whether or not the time for filing a petition for leave to appeal is effective. Rule 316 is the next rule that we wanted to address, and that is a petition to the appellate court to certify the question to the Supreme Court. For whatever reason, 316 has no page limits. I don't think the court ever intended that. So what we're asking is that the page limits be the same as under Supreme Court Rule 367, which is a petition for rehearing, which I believe is 8,100 words or 27 pages. So we would simply ask that that be amended. And since we submitted this package, we've received some requests for friendly amendments, and there is one I'd like to just mention to you, and I can follow up in writing on this. But what we've added is the length of the application shall be governed by Supreme Court Rule 367. We'd like to add the length of the application and answer, because I think the rules should indicate that if an answer is requested by the court, it be limited to the same number of pages, which is 8,100. So I will follow up in writing just to amend our proposal to include both the application and the answer. The next rule is 341. In federal court, in appellate procedure, parties file table of contents and then table of cases. Most appellate practitioners, and I believe the court does as well, likes points and authorities, but many of us also file a table of contents just for the convenience of the court. It's not permitted in the rule, and the only reason why one would not do it, even though it would be more convenient, is that it would not, it would count towards your word count because it's not specifically excluded in the Rule 341. So we would, one, propose a table of contents, and two, any words in the table of content would be excluded, or pages, from the limit that one would be allowed. And then also with respect to the rule itself, under H, we would have as the first point table of contents, and then since we proposed this, there's been a proposed amendment, and I leave this up to the committee as to how they want to handle it. I don't think we ever intended that the table of contents would include the points and authorities followed by an additional section of points and authorities. That would be too repetitive. So it seems to me either the points and authorities would go into the table of contents and then you eliminate the second item in that rule, which is points and authorities, or you could just simply have a reference in the table of contents to the points and authority and what pages they start, and then it could be followed by points and authorities. So that's just a minor amendment. Again, I'll follow up in writing on that. We think it's helpful to the court. We also think it'd be helpful to practitioners to be able to have a table of contents, because the points and authorities only covers argument. And this would allow the court to look to the jurisdictional statement or nature of the case, or other items which are not currently included in the points and authority. Finally, Supreme Court Rule 368, just to be consistent with our prior proposal, under 315, if a corrected opinion is filed, it should not have any bearing on the transmission of the mandate. It shouldn't delay it. So if the court, 2 weeks after the opinion of the appellate court is issued, wants to file a corrected opinion, it does not have any impact on when the mandate would be returned. And that's all I have, Mr. Chair, and would welcome any questions.
Mr. Eaton, because I want to make sure I'm taking some notes here. I want to confirm that you're going to follow up with us on 318C and 341, true?
That's correct.
And the proposals that you have are requesting amendments, they are to be taken individually and not in their entirety, so that if one fails or one goes, so go the other ones also. Is that correct?
Yes, yes. The proposed amendments, and by the way, Mr. Chair, I believe you said 316. That's what I intended. If
No, I have 318C.
no,
and
it's 316. The proposed amendment would have the application under 316 be the same length as under 367, and we would propose amending it to include the answer would be the same length as under 367 as well.
All right, so you're gonna follow up on 316 and 341.
Yes, I will.
Okay, understood. Thank you. Thank you for that clarification. Anyone else questions for Mr. Eaton? Thank you very much.
Thank you.
Our next speaker, Seth Horvath. Seth, you are speaking on two proposals, 1905 and 1914. Are you on the phone or on Zoom?
I am, Mr. Chair. Are you able to hear me okay?
Yeah, I can hear you fine. Just so I understand, how are you going to use up your 10 minutes for both? Do you need 10 minutes apiece? Just so I can kind of set my timer here.
I think I can cover what I intend to say within one 10-minute block, so I'll try to address both within that 10 minutes. I also would like to, if the committee would indulge me, to say a few words on proposal 1911 as well on behalf of the Appellate Lawyers Association. That's the Rule 23 proposal. So I would propose commenting on three proposals during my 10-minute allotment.
That's fine. If you go a little bit over, that's okay. You're speaking on at least two, and now you want to comment on 1911. So go ahead. Thank you so much.
Much appreciated. Thank you. And thank you, other members of the committee, for allowing us an opportunity to speak today. The Appellate Lawyers Association is always very enthusiastic about having a chance to present to the Illinois Supreme Court Rules Committee and offer the thoughts of our organization on various pending proposals. Today, we are not presenting any of our own proposals. We are simply here as a commentator on the three proposals I just discussed with the chair. That's proposal 1914, which has a jurisdictional component to it, proposal 1911, which pertains to Rule 23, and proposal 1905, which Mr. Eaton just walked through in some detail, that contains various technical amendments to the appellate rules. I will do my best to get through those in the remainder of my 10-minute allotment. We have submitted to the committee a letter that articulates the ALA's positions on proposals 1914 and 1905. That is in the public comment section of the Supreme Court's website. It was submitted on 6/16, submitted on 6/10. And so my comments are designed to hit some of the high points, if you will, of our written submission, and also build in some commentary on the Rule 23 proposal, which has been the subject of much discussion. So without further ado, I want to turn first to proposal number 1914, which has a jurisdictional element to it. That involves Rule 303A2. The rule is the rule that says a motion to reconsider a ruling on a post-judgment motion does not toll the time for filing a notice of appeal. This proposal was put forward by Judge Mclaren. He spoke earlier today regarding his thoughts on the need for it. The proposal doesn't target the notice of appeal element of Rule 303A2. The proposal rather suggests clarifying that a circuit court retains jurisdiction to hear a motion to reconsider the denial of a post-judgment motion. So it addresses a slightly different aspect of 303A2 than the notice of appeal aspect. I just wanted to be clear on that. The proposal stems from a very lengthy and very thorough dissent that was submitted in the People v. Orahim case. Judge Mclaren authored that dissent. In Orahim, and I think it is important to briefly put this into a procedural context, in Orahim, the defendant moved to reconsider.
his sentence in a criminal case. And within 30 days of the denial of the motion to reconsider, the defendant then moved to vacate his guilty plea. So motion 1 was denied. Motion 2 was then filed within the 30-day window prior to the time for filing a notice of appeal. The majority and the concurrence in Orahim had a very extensive disagreement and discussion over whether the circuit court retained jurisdiction to hear the second motion. And the proposal is an attempt to clarify the scope of Rule 303A2 and set forth in writing that the circuit court does in fact maintain jurisdiction to hear motions to reconsider the denial of post-judgment motions. The ALA respectfully opposes the proposed amendment to Rule 303A2. It seems to the ALA that this proposal is perhaps better targeted to the criminal rules than the civil rules. Rule 606B is a criminal rule of appellate procedure that addresses the effect of a post-judgment motion on the time for filing a notice of appeal in a criminal case. In addition, the proposal refers to a concept, jurisdiction over the cause generally. The ALA believes that that concept may inject more confusion into the rules than it alleviates. The rules don't tend to address jurisdictional issues explicitly, and it would be an exceptional circumstance for them to do so, as the proposal suggests. In addition, and most importantly, nothing in the current version of Rule 303A2 negates the jurisdiction of the circuit court to consider a motion to reconsider the denial of a post-judgment motion. So with those considerations in mind, the ALA respectfully opposes the proposed amendment to 303A2 and suggests that perhaps the concept of an amendment to address this criminal sentencing issue is better taken up in the framework of Rule 606. I'm going to turn now quickly to the Rule 23 proposal. That's number 1911, just to offer up some comments that I hope encapsulate and echo the position the ALA has historically taken on this rule. The ALA continues to support the position of the Special Committee on Supreme Court Rule 23, in which the ALA participated in 2016. That position is that Rule 23 opinions ought to be citable prospectively as persuasive authority. The ALA has believed for many years now and continues to believe that that position represents a sensible middle ground between abolishing the use of unpublished opinions altogether and making everything precedential on the one hand, and maintaining the status quo of non-precedential, non-citable opinions on the other hand. The Supreme Court has demonstrated a willingness to incrementally revisit the scope of Rule 23. As the Joint Committee pointed out in its 2016 letter, that's the letter that's available on the Supreme Court's public commentary webpage, and that's been resubmitted to the Rules Committee for consideration. As that letter points out, in the early 2000s, the Rule 23 limit on opinion length was abolished, eliminating hybrid Rule 23 and published orders. And at the same time, Rule 23 orders were made available electronically for public consumption and for use by members of the bar. We submit that now, in light of additional technological advances and the overall availability of Rule 23 orders, the time is right to again revisit the rule and certainly to take a measure that does not involve abolishing it in its entirety. And I'll use the rest of my time now to address some of the points that were brought up with respect to proposal number 1905. The Rule 306 component of 1905 was discussed by Mr. Eaton. The current version of Rule 306, which involves expedited interlocutory appeals, states that a court may order the appellant to file additional portions of the record on appeal in an expedited interlocutory appeal under Rule 306. Under the proposal, any party would be able to ask the circuit clerk to file additional portions of the record. We submit that the rule already appears to allow what the proposal is suggesting insofar as it allows either party, after a Rule 306 petition has been granted, to request preparation of the record in accordance with Rule 321 and related rules. So the rule already seems to allow what the proposal would put forward. And in addition to that point, it seems prudent for courts to retain the authority to be able to allow the appellant to put the record together, particularly in situations where an appeal is expedited and the appellant oftentimes has the most interest in carrying the appeal forward on an expedited basis. With respect to the Rule 315 component of Proposal 1905, as well as the Rule 368 component of Proposal 1905, the proposals suggest that the issuance of a corrected opinion should not pause the deadlines for filing a petition for leave to appeal or the deadline for submitting a mandate to the circuit court. Those deadlines revolve around the 35-day time frame set forward in Rule 315 governing PLAs and Rule 368 governing the issuance of mandates. The ALA respectfully submits that one problematic aspect of the proposals is that the notion of a corrected opinion isn't defined. And if an opinion is changed in a substantive fashion, it seems sensible for a party who's filing a petition for leave to appeal to be able to address the correction within the opinion. And the 315 proposal and the 368 proposal would seemingly negate the ability of a party filing a petition for leave to appeal to do so if there are substantive changes within a corrected opinion. With further definitional clarity, the proposals may not be problematic and may be well taken, but the ALA wanted, based on its experience, to flag that issue with respect to the 315 and 368 proposals. I believe I've hit my 10 minutes. If I could have perhaps one more minute to wrap up, I'll address the remaining components of 1905. Is that acceptable, Mr. Chair?
It is. Since you are commenting on several proposals, I'll let you have the time. Thank you.
Thank you much, and I will do my best to be quick. The next piece of 1905 that the ALA submitted comment on is the piece regarding Rule 316. That's the rule on appeals by certificate of importance from the appellate court to the Supreme Court. The ALA endorses that proposal. It seems useful to both bench and bar to include some additional limitations on the page numbers associated with briefing that happens in connection with certificates of importance. The issue the ALA wanted to flag is that perhaps it would be useful within the 316 proposal to clarify that the court to which the proposal is referring is in fact the appellate court, given that certificates of importance are issued by the appellate court. A small technical point, but one worth mentioning nonetheless. With respect to the 318C proposal, the ALA also endorses the 318C proposal. That proposal involves the rule whereby appellate briefs certified by the clerk's office may be transmitted to the Illinois Supreme Court if the contents of the appellate briefs are relevant to the appeal pending before the Supreme Court. The rule would allow transmittal of e-filed stamped copies of those briefs, and that would bring the rule into conformity with general e-filing practices that have been adopted by the court over the last 5 to 10 years. And finally, with respect to the Rule 341 proposal, Rule 341 contains a requirement that's very familiar to Illinois appellate practitioners that appellate briefs must contain a table of points and authorities. As the ALA understood the rule, the proposed amendment would add a requirement that a table of contents be added before the table of points and authorities. That struck the ALA as duplicative. I gather from Mr. Eaton's comments that there will be some clarifying submission tendered to the committee, and the ALA would certainly appreciate the opportunity to review that and comment further if appropriate. And to the extent the clarification is going to resolve the issue of a duplicative submission and duplication between the table of contents and the table of authorities, the ALA believes that that type of clarification would be well taken. I thank the committee for this time to comment. If anyone has any questions about the ALA's positions on any of the proposals, I am more than happy to address the questions. Thank you.
Thank you. Are there any questions for Mr. Horvath?
I have one. Mr. Horvath, thank you for that presentation. You covered a lot of material in a short time. I want to comment on the ALA's apparent opposition to Proposal 19-14, which is Rule 303A2, regarding the court's jurisdiction to reconsider a post-judgment motion. You suggested that you did not think that, you thought that the rule was clear as it is, that the trial court would continue to have jurisdiction with respect to considering the reconsideration on the post-judgment motion. Mr. Mclaren, Justice Mclaren also thought that was clear, but apparently two judges of the appellate court did not think it was clear, which suggests that perhaps a rule amendment would be appropriate. Justice Mclaren suggested that it might be sufficient simply to have the clarification in the comment. You said that the ALA opposes the amendment of the rule. Would the ALA, what is the ALA's position with respect to providing that clarification in the comment, a new comment to the rule?
I think that's a very interesting point. To the extent the ALA were to receive a proposed comment, we'd certainly love and be enthusiastic about the opportunity to review it, but that may in fact address the ALA's concerns, which are premised on the notion that an amendment of the rule could cause a bit of confusion if it's textually amended to refer to jurisdiction. Again, jurisdiction is a concept that's not often dealt with directly in the language of the rules, and the rule proposal as currently phrased would utilize language that doesn't seem to have come from any other aspect of the rules or from any case law that was cited. So to the extent this could be addressed in a comment, I think that could go quite a ways toward addressing the ALA's concern about unnecessarily injecting confusion into the written language of the rules. The ALA is obviously cognizant of the fact that lots of practitioners don't do appellate work on a regular basis, and so we try to be mindful of proposals that change the status quo of the rules in some way, and we try to think forward about how well-intentioned changes might complicate the rules in a way that would affect non-regular appellate practitioners. So the short answer to your question is addressing this issue in a comment may be something that the ALA would find appropriate under the circumstances.
And following up on the basis for the objection is that the rules, I've not surveyed them myself, you're suggesting that they do not typically reference jurisdiction. And I agree that appellate jurisdiction can be a very complicated concept, but lawyers in applying the rules have to deal with that concept, whether it's mentioned in the rule or not. And so I guess I'm a little puzzled why the fact that the word jurisdiction would be in the rule would be not helpful to practitioners. That would certainly trigger to them that they have to research how jurisdiction would apply in this circumstance. And it avoids the confusion that two justices of the Second District Court of Appeals apparently experienced.
It's certainly the possibility that that adding language could have a clarifying effect, and I submit it's also the possibility that it might not. It seems that this provision has caused a bit of consternation, and depending on the viewpoint of the person looking at the provision, it seems to result in different interpretations. I think that we as an organization are of the mindset that given the notion that jurisdiction is typically expressed, or comments on it are typically expressed in case law rather than in rule, If there's a way to continue to observe that distinction, perhaps it's useful and consistent with practice. And the rule, as we've reviewed it, as we've analyzed it in the civil context, it does not seem to bar the type of motion practice that Judge Mclaren's proposal is concerned with. So it's a 2 points critique of the proposal, which starts with the fact that the rule seems to allow what Justice Mclaren would have it clarify, but moreover, a concern that by attempting to clarify the rule, we would simply further confuse. And the notion of addressing via comments has some appeal for those reasons.
Mike, do you have any other questions?
This is a little unfair, but we still have in the audience Mr. Tim Eaton, one of the state's most eminent scholars of appellate procedure, and also a former president of the Appellate Lawyers Association, although he is not here, and many other bar associations. He's not here in that capacity today. And I'm just curious as to whether or not Mr. Eaton has given thought to her or has any thoughts or comments on Proposal 1914 that I've been discussing with Mr. Horvath.
No, I don't, Mr. Rothstein, although I think an addition to the comments may be appropriate, because I can see how that would be clarifying, because obviously if two justices of the appellate court believe it says something different, I think it's worthy of at least some comment as to what it means.
Thank you.
And with all due respect, Mr. Chairman, can I comment, since Mr. Horvath criticized my rule, my request to modify the rule and basically invoke something that was not part of the agenda on Rule 23. I'd like to make one point, if I could. It will only take a minute, if I could.
It has to be 1 point in 1 minute, because, just
That's
because.
right. That's all I want, is 1 point,
Okay.
1 minute. He references the materials that were submitted. What he fails to mention is that there was a letter dated December 7th, 2016 by Michael J. Tardy, of the director of the administrator of the Office of Illinois Courts, that basically in effect said where the appellate justices were surveyed on that particular proposal that the Illinois appellate lawyers proposed in this regard, and they voted to make no changes in Rule 23 at that time. It's been 4 years. So he failed to mention that letter or that fact.
Thank you. I have one other point, and then I'm going to actually revise the agenda a little bit. I think it's unfair that we try and go through the entire agenda without a break, given the fact that people have been on hold for a while and you don't have, the accommodations that we typically have at the Thompson Center or at the Illinois Supreme Court building. So I do I'm going to ask Amy, actually, does she have the letter that was referenced by Mr. Eaton, so that we have the totality of everything when we are deliberating?
I don't have it, but I can get it. I can get it before the end of this hearing, I think, and I can get it out to the committee. I can make a phone call if we're going to do a break.
Yeah. And then what I would like to do is to give everybody the benefit of a break. Right now I show it's 12:50. Why don't we reconvene at 1 o'clock? This is a good opportunity for a break. We'll start a new proposal, and that will be with Ms. Riddick. We are behind schedule, obviously, because we had few difficulties in the end, but it looks like they're all ironed out now, and we're proceeding well. And I'm hoping to get through the rest of the schedule very smoothly. Don't touch your settings. Don't move anything. Don't click anything off. Let's stay where we're at. Maybe just mute your phones, and we will reconvene at 1 p.m. sharp. Thank you. All right, hopefully we have everyone on. Are you able to hear me? All right, so hopefully we have everyone back on. We're about 1 past the hour right now. Are we ready to start with our next speaker, Lauren Riddick?
Yes, I'm here.
Very good. Ms. Riddick, you are a proponent of 1910. And the floor is yours.
Thank you so much for having me. My name is Lauren Riddick. I'm with Cadillus and Associates, and I have two suggested changes to 113F, which deals with mortgage foreclosure sale notices. I'll be brief. First, the rule as it currently stands requires hard copy mailing for mortgage foreclosure sale notices, despite the electronic notice modern update provided by 11C. This appears to be an unintentional oversight. Therefore, the proposal permits electronic notice for those parties providing an email address. Secondly, to avoid uncertainty and inconsistencies, the proposal directly references the notice exception provided in 1507C4 for those sales occurring within 60 days of an adjourned sale. I'm happy to answer any questions. Thank you for your consideration.
Does anyone from the committee have any questions? Sounds like there are none. Ms. Riddick, thank you very much.
Thank you.
Before we begin with our next speaker, which is Dwayne Schuster, speaking on Proposal 2004, I want to remind everybody to please mute your phones if you are not speaking. Thank you. Mr. Schuster, are you on the Zoom call?
Yes, I am. Can you hear me?
Faintly, but yes, I can hear you.
Okay. Excuse me. I'll see what I can do with the volume adjustment.
Yeah, I can't hear you well. I don't know how everybody else is hearing you, but I know on my end it's a little faint. So maybe if you can come closer to your speaker or your microphone, I mean.
It's very faint for me too.
Okay. Yes, if you could then please.
And I have I have the program on my iPhone as well, but I'm logged in, but I don't have any audio coming out of it. Can you hear me at this point?
It's a little bit better. It's not the best, but I think it's if that's what we can do, we will endeavor to do our best. So please proceed.
I apologize for the glitch there. May it please the chairman and the members of the Rules Committee, I want to thank the Rules Committee for the opportunity to address you today. My name is Dwayne Schuster. I'm the staff attorney for the Illinois Board of Admissions to the Bar. And I have been staff attorney with the Board of Admissions since February of 2015, but just by way of background, I took the bar exam in 1989, and I was admitted to the Illinois bar in 1989, and I have been practicing law in Illinois for the better part of the past 30 years. With the advice and consent of the Board of Admissions, our director and administration and I have drafted some proposals for amending Illinois Supreme Court Rule 705, which deals with admission on motion. Our proposals seek to resolve some recurring issues which potential applicants have raised with the board with some frequency regarding the basic eligibility requirements for admission on motion. Along those lines, I will start with just reciting briefly from the preamble of Rule 705 as a sort of segue into exactly what we're discussing and what the potential problems are. Rule 705 states that any person who has been licensed to practice in the highest court of law in any United States state, territory, or the District of Columbia for no fewer than 3 years may be eligible for admission on motion on the following conditions. That's a key point. Note that it is admission on motion contingent on meeting certain conditions. We get many inquiries at the Board of Admissions at least one a week, and that's probably a very conservative estimate. You know, we get phone inquiries or email inquiries asking about reciprocity in Illinois or the ability to waive in Illinois, and we don't really have that, strictly speaking, in Illinois. The term is admission on motion, and it's subject to certain very strict requirements. Along with the preamble, I'll just segue into Rule 705M, in which the Illinois Supreme Court explicitly stated that admission on motion is not a right, and it's the applicant's burden to establish that he or she meets each of the foregoing requirements. The proposed amendments to Rule 705 that we have drafted are intended to clarify some of those conditions and some of those requirements which have been problematic as far as applicants understanding what the qualifications are, and as far as the board being able to apply the provisions of the rule to the specific facts and circumstances of each applicant's background and work history. And the First Amendment we're proposing is basically adding language to Rule 705D to specifically define the term jurisdiction. And the reason we are proposing that is because the word jurisdiction is used to describe other basic, very essential requirements for admission on motion in Illinois. But even though jurisdiction is used as a key factor, the term itself is not explicitly defined in the rule as it currently stands. The reason we are proposing to add a definition of jurisdiction in Rule 705D is that subparagraph D is the first instance in Rule 705 in which the word jurisdiction occurs. And just to refresh the committee's recollections, Rule 705D states the requirement that the applicant must be in good disciplinary standing before the highest court of every jurisdiction in whichever admitted, and is at the time of application on active status in at least one such jurisdiction. Another very important and crucial instance where jurisdiction, the term jurisdiction, is used to define a requirement of eligibility in Rule 705 is subparagraph I, Rule 705I, which states that subject to certain specified exceptions, for purposes of this rule, the term lawful shall mean the practice was performed physically without Illinois and either physically within a jurisdiction in which the applicant was licensed or physically within a jurisdiction in which a lawyer not admitted to the bar is permitted to engage in such practice. That sentence that I just read to you has proven to be extremely problematic for potential applicants as far as understanding the eligibility requirements, and it's been a thorny issue for the board in determining how do you define where the practice was performed physically. We believe that defining jurisdiction specifically, what it means for purposes of Rule 705 will add some clarification. And what the Board of Admissions is proposing is that you basically take the language that is implicit in the preamble and you reiterate it explicitly in Rule 705D. Note that the preamble talks about applicants who have been licensed to practice in any United States state, territory, or the District of Columbia for no fewer than 3 years. What the board is proposing is that in subparagraph D, where it speaks of the applicant establishing good disciplinary standing in every jurisdiction in which he or she has ever been admitted, we are proposing that for purposes of this rule, the term jurisdiction shall mean any United States state, territory, or the District of Columbia. The reason we are proposing to make that definition explicit is because it is not uncommon. I would say it happens between half a dozen to a dozen times a year. Potential applicants will insist that they are eligible for admission on motion under Rule 705 when they have practiced in a state jurisdiction that differs from the state jurisdiction where they actually hold a law license. That causes problems as far as interpreting and implementing the requirement in Rule 705I that for purposes of this rule, the term lawful, and what that means is lawful practice, the definition of lawful practice, shall mean the practice was performed physically without Illinois and either physically within a jurisdiction in which the applicant was licensed or physically within a jurisdiction in which a lawyer not admitted to the bar is permitted to engage in such practice. From time to time, we are contacted by potential applicants who assert that they practice exclusively federal law, that they are patent lawyers, that they are federal immigration lawyers, that they are federal income tax lawyers. However, they have worked for private firms, private entities. In some cases, they've hung out their shingle and their sole practitioners. And in some of these instances, the individuals attempting to apply under Rule 705 acknowledge that they've actually set up offices within the state of Illinois. And their argument goes along the lines of, well, my jurisdiction is the jurisdiction of the federal courts, or the jurisdiction of the U.S. Patent and Trademark Office, or the jurisdiction of the various federal immigration tribunals. And even in cases where the individual is within Illinois, has an office within Illinois, they assert that, look, as far as my practice of law, I'm not really practicing in Illinois, or I'm not really practicing in, let's say the person bears a law license from the state of Missouri. The person will say, I'm not really practicing law in Missouri. I'm practicing law in the federal system. It is the position of the Board of Admissions that that is not and cannot be what the Illinois Supreme Court intended. Again, if one refers to the preamble, the very first words in Rule 705, it's clear that the Illinois Supreme Court was speaking of applicants who are licensed in the highest court of law in a United States state, territory, or the District of Columbia. And as far as the argument that, well, my federal practice comports with Rule 705I, one of the specific exceptions that is already noted in Rule 705I, basically an exception to the requirement that you have to show the practice was performed physically outside of Illinois and within a jurisdiction where you were licensed, is practice falling within subparagraph G3 or G6. If one refers to Rule 705 G3 and Rule 705 G6, those are provisions defining what the practice of law is, and G3 applies to attorneys who are employed by a federal court. Rule 705 G6 covers attorneys who work for the federal government, a federal agency in some capacity, such as a United States attorney, or, for example, a lawyer who works in the United States military as a judge advocate. Those exceptions, the court would not have put those specific exceptions for that particular specific kind of federal practice into Rule 705I if the court had intended that as a general matter, practice either physically within a jurisdiction in which you're licensed or physically within a jurisdiction in which you are admitted encompasses any federal jurisdiction where you are admitted.
So, Mr. Schuster, I want to be fair. You know, you've gone a little bit over your time here. If you wouldn't mind being able to wrap it up for us, please.
Okay. As I said, the board just believes that adding that very simple language, it's basically adding one sentence to Rule 705D would clear up and resolve some of these difficulties. It would provide clarity for the applicants. It would provide clarity for the board as well. We did suggest further amendments regarding applicants who engage in remote practice and giving those applicants some qualifying practice credit. But I realize I've gone over my time, and on behalf of the Illinois Board of Admissions, I would respectfully request that the committee and the Illinois Supreme Court consider the proposed amendments to Rule 705D and Rule 705I. Thank you.
Thank you, Mr. Schuster, for the very thorough presentation. Much appreciated. Any member of the committee have any questions or comments for Mr. Schuster? I hear none. Thank you. Thank you very much.
Thank you, sir.
We move on to, it appears, this is our last proposal for the day. We have 5 speakers lined up, and this is Proposal 2007. That is correct. And our first speaker is the Honorable Jorge Ortiz. Are you on the Zoom call, Your Honor? Judge Ortiz, before you start, I'm going to ask you just to say a few words so that we can make sure that we can hear you well.
Good afternoon. Can you hear me?
Yes, we can hear you. It might be a little echoey. Are you on speakerphone by any chance?
I am not. I'm in my chambers on my computer.
All right, it's a little bit better now. I think you might be closer to the microphone.
Okay,
Amy, are you having any problem hearing? Good. All right, Your Honor, if you'd like to proceed then, please.
Thank you, Mr. Chair and members of the committee. On behalf of the Access to Justice Commission, I am pleased to present the Commission's proposal for a new Supreme Court rule titled Practice and Procedure in Eviction Act Cases. In a nutshell, this rule would require an eviction complaint to include a copy of the written eviction notice or demand and, where applicable, the relevant portions of the lease. The rule is intended to supplement existing pleading requirements set forth in the Eviction Act. So presently, a demand for possession or a notice of termination is almost always a prerequisite to the filing of an eviction action. And the Eviction Act provides that an eviction complaint state that the plaintiff is entitled to possession of the premises and that the defendant unlawfully withholds the possession thereof. And so the factual basis for a termination of tenancy or lease or authority for demand for possession is detailed in the notice of termination or demand for possession served on the tenant prior to the filing of the notice, or rather prior to the filing of the eviction action. Additionally, demands and notice must provide language indicating termination of tenancy and, where applicable, provide for a cure period. The notices and demands provide tenants with a basis for understanding why their landlords are seeking to evict them and ways to cure the violations when applicable. However, notice and demand documents frequently are not attached to eviction complaints. Similarly, although the breach of a lease term may form the basis for a termination notice and eviction complaint, the lease or relevant portions of the lease also are rarely attached to eviction complaints. So Section 2606 of the Code of Civil Procedure, as we know, requires the written instrument upon which a demand or claim for defense is founded to be attached to any pleading. And this provision has almost never been applied to eviction cases in the past because Section 9-106 of the Eviction Act does not expressly require it. Now, I was able to find one rare exception. There's a Rule 23 order written by Justice Neville in 2012, the Zachman case, Z-A-C-H-M-A-N. The citation is 2012 Illat 1st 120837. In that case, Justice Neville affirmed dismissal of an eviction complaint due to the failure to attach a copy of the lease to the complaint. And you've all heard a lot about Rule 23 and its limitations. So the benefits of the proposed rule are that that the rule would bring the Eviction Act in line with Section 2-606. This would also increase efficiency and transparency in the eviction courts in that it would allow the parties to assess initially the basis for the termination and the adequacy of the service of notices or demands prior to a court appearance. The rule would also reduce the need for discovery of these crucial documents, although the rule is not intended in any way to preclude discovery in these cases. The benefit to the attorneys is that they would be able to review the demand, notice, or lease at the outset, and would allow them, both private and legal aid attorneys, to better evaluate the eviction case and determine whether to accept the matter for representation or advise landlords and tenants on how to proceed. The rule would assist self-represented landlords in the presentation of their cases. Many come to court without these documents, and cases are delayed or dismissed as a result. And under the new rule, the landlords would have these documents available at every court date and would be better prepared to present their cases at trial. The benefit to self-represented tenants is that they would presumably be better positioned to present their cases, and they would better understand the basis for the action and could, again, be better prepared to assert timely defenses. Also, this would simply improve efficiency and enhance access to justice in our courts. Again, by reducing continuances and generally expediting matters. So in light of the current health and economic crises facing our communities and the anticipated increase in eviction filings, the Commission feels the proposed rule may be particularly timely and perhaps even urgent. And so therefore, on behalf of the Commission, I thank you very much for your consideration of this proposal.
Thank you very much, Judge Ortiz. Any questions or comments for His Honor? Maybe I just, just anecdotally, maybe if you could share some examples, maybe some better everyday examples of where the problems come in, not only on behalf of the litigants, but also for the judges when all the documents are not attached. And that's what it sounds like what we're talking about here is just a little bit more transparency, having everything available to everyone at the outset. Is that pretty much the goal here?
Absolutely. Everyone would know what is expected of them, what's required. This is the basis for the action. Here are the documents. Here's the evidence. This would reduce the number of continuances. This would reduce the number of dismissals, I think, also, due to a failure to have the required documentation. And I can't tell you, I mean, I heard eviction cases years ago, but our judges in Lake County who presently hear eviction cases tell me that they constantly have to continue cases because of the lack of documentary evidence.
I mean, really, there's really no prejudice to anyone here because we are talking about documents that exist. You would assume that a tenant has a lease, that a landlord, was in performance of a contract at the time. So I don't see, unless I'm missing something, is there any prejudice to anybody in being transparent and having the documents available?
I don't see any prejudice to it, and in fact, I think this would also allow for a better practice. And as I said earlier, bring the Eviction Act in sync with Section 2-606 of the Code of Civil Procedure.
Anyone have any questions or comments, follow-up? Thank you very much, Judge Ortiz.
Thank you.
Next up, we have presenting on the same topic is Samira Nazim. Are you on the Zoom call?
Yes, I am. Can you hear me?
We can hear you just fine. Thank you.
Great. All right. Thank you. Good afternoon, everyone. And thank you for the honor of speaking in support of Proposal 20-07. I will try to keep my remarks brief because I know many other people are speaking about the same rule and it's getting quite late. And my name is Samira Nazem. I'm the Director of Pro Bono and Court Advocacy with the Chicago Bar Foundation. I wanted to just add a little bit of background about how this rule proposal originated and to echo some of the points made by Judge Ortiz just a moment ago. The idea for this rule originated from the Circuit Court of Cook County's Pro Se Advisory Committee. That committee is a coalition of representatives from the judiciary, the court, the clerk's office, sheriff's office, the private bar, legal aid community, and other stakeholders who are interested in access to justice and improving the experience of people without lawyers in the circuit court. Several committee members expressed concerns about some of the challenges they were seeing among self-represented litigants, both tenants and landlords, in the eviction courtrooms in Cook County. And those challenges, some of which Judge Ortiz outlined a moment ago, included tenants who would arrive at court without having a clear understanding of the allegations against them that gave rise to the eviction case, landlords who would arrive at court only to find their cases were continued or dismissed because they didn't have the required notices to establish their case and move forward. Tenants and landlords both who were unable to get assistance from legal aid organizations, rental assistance programs, or other services because they did not have the documentation necessary to be reviewed and screened by those programs. And cases just being slowed down and delayed because of a lack of basic information that's core to the case. So identifying the common theme in all of this was that the case files were missing this basic foundational information, including the eviction notices and the lease. The committee drafted a rule proposal and then shared it with the Access to Justice Commission that would rectify this issue by requiring the landlord produce this basic documentation along with the eviction complaint. As Judge Ortiz noted, this does not create a significant burden for the landlord since these are documents that already exist and should be within the landlord's control and are documents that are necessary to establish the case and will need to be provided eventually anyway. But by producing this information from the get-go, the result is a complete case file that will allow for greater efficiency and more transparent process with all of the stakeholders. I do also want to stress that this proposal is even more timely now because many of our courts are anticipating an increase in eviction filings in the coming months as a direct result of the COVID-19 pandemic. Many of these courtrooms, which are already high volume and under-resourced, will be stretched even further as we see more cases coming through the court system. Our legal aid, mediation, rental assistance programs, and others will also be stretched very thin. And we'll see a lot of stresses on our court system and our legal system and legal aid support system in the coming months. And it's more critical than ever that we look for ways to streamline this process and increase efficiency for the courts and for all of these stakeholders. So as Judge Ortiz noted, this rule is intended simply to provide greater transparency and efficiency and not to create any additional burdens or work for any of the stakeholders. It will allow for tenants to have a clearer understanding from the time they receive the eviction complaint of what the allegations against them are so they can adequately prepare or seek appropriate help from legal aid or other organizations. It will ensure that landlords have their paperwork in order so cases won't be delayed or dismissed, creating a burden on the court system and potentially requiring more court dates at a time when we're all trying to keep the number of people in the building to a minimum. And it will allow legal aid organizations and mediation programs and other support systems to more effectively triage cases and provide much needed assistance to self-represented litigants to help negotiate settlements and to ultimately reduce the burden on the courts and to reduce the harm of eviction in our community by allowing for the best possible outcomes in these situations. And judges will have access to more complete case information when the predicate notice and the lease provisions are included as part of the case file, rather than having to wait until potentially the date of trial to see those documents for the first time. So I don't want to take up too much time. I know it's late and I have other colleagues who will be speaking more specifically about how this rule will impact their practices and again, create better outcomes and efficiencies for everyone. But I want to thank everyone for the opportunity to speak and to encourage you to adopt this proposal because it will make the court system more fair, efficient, and transparent for everyone.
Thank you.
Thank you.
Anyone have any questions or comments for Ms. Nazim? Okay, hearing none. Mr. Rona, are you on the Zoom call?
Hi, yes, this is Patricia Rona. Thank you very much, Mr. Chairman. Distinguished members of the committee, I'm Pat Rona. I'm the Director of Legal Services at Carpel's Legal Aid in Chicago, and it's my pleasure to be before the committee today to speak in favor of Proposal 2007, this proposed new rule on eviction pleadings. So Carpel's runs Cook County's Legal Aid Hotline, as well as the statewide Illinois Armed Forces Legal Aid Network Hotline. We also operate 4 court-based advice desks, including one where we see a very high volume of eviction cases. Every year, we conduct about 65,000 legal consultation with clients in all legal subjects, with eviction being our highest volume issue. In a year, we advise pro se litigants in usually over 6,000 landlord-tenant matters. So like the other legal aid agencies that are involved in our discussion today, Carpel's advises pro se tenants in eviction. But unlike our colleagues, Carpel's also helps pro se landlords as well, such as a senior citizen who owns a 2-flat, lives in one of the units, and rents out the other. Carpel's advises on both sides of this eviction equation. And before my current role at Carpel's, I actually practiced in the Cook County eviction courts on behalf of private and public landlords. So I really understand the perspective of the landlords bar. So today I'd like to speak on why the proposed rule is a much needed improvement from both sides' perspectives. So first, as to the tenants, requiring the attachment of the 5, 10, or 30-day notice to the eviction complaint will really help identify to the tenant and his counsel, if he has one, any initial defenses of notice defects or service defects. Many tenants report to us that they never got any notice, but the landlord is always going to have something to hand up as part of their case in chief. And they often do so very quickly, never showing it to the tenant, their opponent, and the tenant may not know to ask to review the exhibit before it's received by the court. Some judges don't raise the issue, asking the tenant, did you receive this notice? How did you receive it? So at trial, the tenant often has not seen, nor is even really allowed to lay eyes on this proffered notice and affidavit of service. Attaching this notice to the complaint will give the tenant a meaningful opportunity to review and fashion a defense based on that notice. As the correct notice in a proper form that's been properly served as a jurisdictional prerequisite in most eviction actions, it is reasonable to give the tenant and their attorney the fullest opportunity to review this important exhibit. Service of that notice is also a problem. If the notice and its affidavit of service were attached to the complaint, the tenant would have a meaningful opportunity to review defects in how the notice was served. Many landlords just shove the notice under the door, they stick it in a mailbox, and yet they fill out in the affidavit that the tenant was personally served. The tenant may not ever have even actually received it. Our permitted manners for the service of notices are in place to protect the due process of tenants. Landlords should be required to forward those specifics with the complaint so the tenants can review and formulate any objections or defenses they have to the service of the notice. Similarly, attaching the lease and its provisions alleged to be breached is important to formulating the tenant's substantive defenses, as tenants often don't even have a copy of their lease. Tenants very often say, well, I signed the lease, I gave it to the landlord, and he never gave me a final signed copy back. So I really have no idea what provision of the lease I may have violated because I've never read the lease because I don't have it. Particularly in eviction, which is an expedited proceeding, there's usually no document discovery in a non-jury case, of course, and the first court date is usually the day of trial. So some notice of what the tenant is alleged to have done wrong would be helpful. The proposed rule will give tenants this important opportunity to prepare their defense. Under our current eviction court trial system, it's all too often trial by surprise, and it's very difficult for a pro se tenant to frame defenses based on a written notice or a written lease on their feet, Perry Mason style. That's hard for even lawyers to do. So the proposal of these required attachments will provide some advance warning to the tenant of what the eviction claim is actually about. Further, there are some landlords, particularly those who are proceeding pro se, who do file baseless or at least procedurally defective eviction cases. Having these important documents served on the tenant as part of the complaint would be very helpful in determining the actual merits of the case against the tenant. Finally, as to tenants, improperly filed eviction cases are no small matter. Many future landlords are not interested in the details of whether a past eviction case was well-based, procedurally defective, or otherwise. They just do a court record search, they find an eviction case on this applicant's record, and the applicant just doesn't get the new apartment. Because an eviction matter is such a negative mark on the tenant's record, this rule will assure that eviction cases that are well supported with proper notices and lease provisions are filed. So now turning to why the changes are also good from the landlord's perspective, because the 5, 10, and 30-day notice is a required exhibit at an eviction trial, assuring early on that the landlord even has the document is a very good idea. This will keep pro se landlords from suing without the required notice, which all too often occurs. They don't know that they have this jurisdictional prerequisite of serving a written notice. They just know they haven't been paid their rent. They jump ahead, they go to the courthouse, they file an eviction case, they pay a filing fee, and they go to their court date thinking they're getting an eviction that day of their tenant, only to have their case dismissed for lack of the statutory notice that confers jurisdiction. So attaching that notice will prevent wasted time and resources for all concerned, as Samira pointed out. Further, the attachment of the notice may prevent pro se landlords from proceeding on a defective notice. Is this the right type of notice? Is it dated? Was it served properly? Have the requisite number of days passed before the case is being filed with the court? When you make a document part of a pleading, it will give the landlords pause to ask, is this document correct? Have I done the right things with it? This kind of scrutiny should be given to the notice before the landlord is offering up the notice in court. The attaching of an exhibit to a pleading that is filed under Rule 137 has to raise the scrutiny of that exhibit. Unfortunately, I have seen perjured false notices in my years of eviction practice. So the requirement the notice be attached will give any unscrupulous landlord pause before proceeding on a fabricated notice. Further, for the landlord that is not a bad actor, but just is not that well informed on the law of eviction, if he can scrutinize his own evidence and see that the notice is defective on its face or wasn't served properly, it's better for the landlord, for the tenant, and the courts that that's known early on. And this requirement of it being attached to the complaint could provide that benefit. If this facilitates a chance for discussion between the parties or their counsel, then I think we'll have more amicable resolutions that will be more likely if these documents can be reviewed before trial, and thereby will save everyone time and allow for better outcomes for all sides. As Judge Ortiz noted, by requiring the attachment of the lease provision that is alleged to be violated, this proposed rule will be consistent with our civil practice statute of 735 Illinois compiled statute section 52606, which requires a claim based on a writing must attach such writing to the complaint or plead why it cannot be attached. These documents must be produced at trial anyway. They exist at the time the complaint is drafted. I always have felt that the lease, or at least the pertinent provisions, should be attached under Rule 606 in an eviction case, but they seldom are, as the judge points out. This new rule will make the breach of lease eviction matters like all other matters in the Illinois courts that are based upon a written contract. The lease contract goes to the very heart of the landlord's claim, and the complaint should fully set forth those provisions. The proposed rules will help the pro se landlord organize his evidentiary case. Being required to attach the lease provisions that substantiate the landlord's position assures that he even has that lease agreement, that he's read it, that he's given the notice that references the pertinent provisions violated. Again, that will all go a long way to having his evidentiary evidence prepared, his documentary evidence prepared as he needs to have it at trial. At Carpels, we would really prefer that a pro se landlord go away from one of our desks with a well-pleaded eviction complaint that has all the critical evidentiary attachments, and that we would know then that the main pillars of the pro se landlord's claim are all in the paper pleadings. This is superior to just hoping that that pro se landlord will remember to bring the lease to court, remember the notice, the affidavit of service. He will know or remember how to offer them up to court, be able to properly quote for them, and be comfortable arguing before the bench of how the lease was violated. That's a real stretch for most pro se landlords, so it would be helpful to both the bar and the bench if the written complaint and its attachments told most of the landlord's story. I believe that this proposed rule will also be assistance in organizing landlords' counsel as well. In what is usually a very high volume of practice representing landlords, I know that these requirements would have helped me to be better prepared to present my eviction cases in court, as there was at least one occasion when the client delayed in getting such documents to me, and I got the 5-day notice or the lease the night before, and before the hearing, only to find that the notice was somehow defective or the lease didn't quite say what my client thought that it did. So in closing, in a world where the average non-jury eviction trial lasts about 2 minutes, It's essential that the court have most of the pertinent evidence before it attached to the complaint. Eviction is a very summary proceeding, and for the record to include these critical documents of the statutory notice, the lease, and its applicable provisions, that would be an important step toward assuring that justice is done in these cases. Evictions has always been an important legal proceeding, and it's even more so now, as Samira said, as we as a legal system face an anticipated onslaught of evictions due to COVID-19, our mass unemployment, and the economic downturn. So we have an opportunity here to assure that evictions are done lawfully in meritorious situations with required due process being afforded to the tenant. So this proposed rule will take us further toward that goal. I'm happy to address any questions from the committee, and I really appreciate your time and attention to this issue.
Thank you very much for that explanation. I appreciated hearing the perspective from both sides, both from landlord and tenant. Does anyone have any questions for Ms. Rona? Comments? Thank you.
Thank you.
Next up, we have Connor Malloy. Are you on the Zoom?
I am.
Mr. Malloy, the floor is yours.
Thank you, everybody. My name is Connor Malloy. I'm from Lawyers Committee for Better Housing. Thanks to the chair, the committee, and my colleagues for attending this. My current role at Lawyers Committee is I run a project called Rentervention, which is a 24-hour chatbot that helps Chicago tenants deal with eviction issues. Before I was involved in this project, I was helping a lot of these landlords that Pat was just talking about, with your small and medium-sized landlords across Chicago who may have just one unit to rent out, or just a small operation. And I can tell you that a lot of these landlords, in my experience, have issues with the notice or various procedural elements. And I think one of the things that this rule will work towards is to be able to create the types of forms for pro ses to be able to effectively prosecute their case. But when they couldn't, and that was something that I experienced commonly, because about 1 in 5 evictions that are filed in Cook County are by a pro se landlord, that's when we would get the phone calls, because I knew to solicit those landlords that were filing pro se, because they were bound to botch something up along the way. So having the notice requirement, and all notices are not created equal. I've seen some notices out there that aren't too hot. Allows a landlord to have that type of self-scrutiny that Pat was just talking about. The other part of this is there's two categories of notices that we're talking about here. You have your non-payment of rent, and what this is asking for is that you just provide the notice. There is in your lease some talk about how much is owed per month or per week, which is not being asked to be able to put into the pleading. It's just for those types of evictions that are proceeding on a default, like you couldn't have a dog in your apartment and suddenly woof woof. So that's, when we talk about the prejudices or the burdens on landlords, it's a very small percentage of cases in my experience, and not to get in too much of an exaggeration here, but probably about 1 out of every 100 cases that I dealt with was based upon a 10-day notice for some sort of a breach of the lease. A lot of them were otherwise a 5-day notice or a 30-day notice for no cause. Again, these types of proceedings that we're looking at are summary proceedings. So, for a lot of my former clients, it was always time and money, right? Why is this case dragging on so long? So when they would find themselves in court without a notice and the judge sent them packing, they're starting to shoot themselves in the foot on prosecuting their own case. And we would commonly have to refile for them, A, because there was no notice, B, because the notice was deficient, or C, for a variety of reasons that landlords or just pro se litigants in general can find themselves stumbling in this type of proceeding. So I want to keep this super duper brief, but this notice provision goes the distance in being able to provide advocates on both sides of the equation with the ability to have everything in front of them. You're showing your hand to be able to come to a resolution if everything's on the up and up. And I know that there's a whole lot of discovery that can be done in eviction cases, but really, the meat and potatoes of the discovery is going to be in that notice and be in those lease provisions. That's going to be your issue there. And thank you again.
So I guess I do have a question, and it could have been addressed earlier, and excuse my ignorance for asking. And I understand that we had one perspective that gave us, you know, Ms. Rona gave us the landlord and tenant perspective, and then we have the judicial perspective from Judge Ortiz. Is there an organization out there that represents landlords that should be on this call or should be aware of this? And I'm assuming they've been given notice and would have had a chance to comment. Is that something that anybody that spoke earlier wants to comment on?
I wouldn't be able to speak to that myself, sorry.
Mr. Chairman, at Carpels, we do address pro se landlords. So as Connor was saying, it's not the most common thing that comes to legal aid, but we do represent probably several hundred in terms of helping them figure out how to draft and proceed on their matter. But in the legal aid community, there's really no other legal aid organization that represents landlords in residential eviction. Of course, there is a private bar that certainly covers that area.
All right, thanks. Any other questions before we move on to Mr. Lawrence Wood? Are you on Zoom?
I am. Can you hear me?
Have you been on the call since the start?
I have, yes.
All right, you get 30 minutes to finish. Just kidding.
I can do that.
All right, you are our last speaker, and thank you very much for your patience. You have the floor. Your time is set.
Thank you. And to address the last question that was directed to Mr. Malloy regarding landlords, I don't think that we have any landlords representatives aside from Ms. Rona on the call, but I have been at several meetings with landlords representatives and judges and Samira, and I've heard their arguments regarding this proposed rule, and I do want to address some of those, although I know no landlord wants me as their representative. I am a supervisory attorney with the Housing Practice Group at Legal Aid Chicago, formerly Legal Assistance Foundation of Chicago. And Legal Aid Chicago is the Midwest's largest provider of free civil legal services to people who are living in poverty or are otherwise vulnerable. And the Housing Practice Group focuses a lot of its work on preventing unwarranted evictions. We also focus on subsidized housing residents for reasons that I'll get to later. I also, for the last 20 years, have taught a class, clinical course on poverty and housing law at the University of Chicago Law School. And I've been at Legal Aid Chicago for 30 years. So I've been in the eviction courtrooms for the past 30 years. And I think it's important to note that there are more than 30,000 eviction actions filed every year in Cook County. And as Pat noted, the typical trial lasts about 2 minutes. Because these are summary proceedings, there is a common misperception that eviction actions are simple and routine matters involving relatively low stakes. Nothing could be further than the truth, especially in the subsidized housing context, where low-income residents are facing eviction from the only decent housing they can afford. But the misperception that I just mentioned has led some to conclude, and I've seen this over and over again in the past 3 decades, that eviction actions may be resolved without adherence to the basic rules of civil procedure. And the most commonly ignored rule is the one requiring a plaintiff to attach to its complaint all the written instruments upon which the complaint is founded. The proposal that we're considering now and that I urge you to adopt solves this problem by mandating that every eviction complaint include the plaintiff's termination notice and relevant portions of the lease agreement. This proposal is vitally important for 4 reasons, and George Ortiz, Samira, Pat, Connor have already touched on some of these, and I don't want to just repeat what they said. But the first reason is that requiring the plaintiff to attach the termination notice and relevant lease provisions to the complaint would ensure that these documents are always available to the judge, who can then quickly focus on the relevant issues and determine whether the plaintiff has complied with some essential elements of its prima facie case. And this would be an enormous benefit, as Judge Ortiz mentioned, in high volume courtrooms where the vast majority of defendants are unrepresented and where many plaintiffs also appear pro se. Second, this proposal would help tenant advocates like myself and my colleagues properly assess each case and decide whether it warrants our involvement, a decision that we have to make quickly in summary proceedings like eviction actions. Our clients are, as I noted before, for the most part, subsidized housing residents who are facing eviction from the only decent housing they can afford. These tenants generally have copies of their landlord's complaints. And these complaints allege only that the defendant unlawfully withholds possession of premises to which the plaintiff has the superior right of possession. But they frequently do not have copies of their termination notices and lease agreements. They may have never been given a lease agreement. They may have signed it but never gotten a copy. As Pat noted, many tenants state that they never even received the termination notice. That makes it difficult for tenants advocates like myself to determine why the tenant is facing eviction. And in the subsidized housing context, it makes it difficult for us to identify the federal statutes and regulations, HUD guidance, and other policies that govern their tenancies. And in the subsidized housing context, I cannot tell you how complicated this can get. There are many different subsidized housing programs, public housing, Section 8 project-based programs, the Housing Choice Voucher Program, many others, all governed by different sets of federal statutes and regulations. And we need to know which of these lease provisions and statutes and regulations apply. And we can gather that information only if we have a copy of the termination notice or the lease agreement. Landlords advocates will argue that we can always obtain the necessary information through discovery, but unless we are going to represent every tenant who requests our assistance, we need the information before the discovery process begins. I will also note that my colleagues and I have had the experience over and over again of calling the landlord's attorney and requesting the termination notice and the lease agreement. And the landlord's attorney will say, you'll get that through the discovery process. We're not going to give it to you now. So it makes it, again, very hard for us to determine what the relevant law is and whether the case warrants our involvement. Third, and Samira and Judge Ortiz noted this, and Pat as well, the benefits of complying with the proposed rule far outweigh the cost. It is difficult for me to imagine how a plaintiff would lack a copy of a termination notice that is required to be served before filing, or the governing lease. And the relevant portions of these documents run no more than a few pages. The termination notice is just going to be one page. Landlords advocates in the subsidized housing context will point to the fact that public housing leases or HUD model leases can run 27, 30 pages, but they do not have to attach the entire lease under this proposed rule. They only have to attach the relevant provisions, which would be the cover page so that we can tell what kind of housing is involved, and then the lease provisions that the tenant allegedly violated. So we're asking the landlords to attach no more than maybe 3 pages to the complaint. Fourth, the proposed rule will resolve what has been a surprisingly contentious issue in the trial courts, and the Illinois Appellate Court will never address this, although Judge Ortiz noted that Judge Neville had issued a Rule 23 order on this issue that, of course, cannot be cited. It is difficult to get this issue to the Illinois Appellate Court for a couple of reasons. First, not to brag, but my housing practice group has a success rate of well over 90%, and so we don't appeal most decisions. Furthermore, if we're going to try to get this issue up to the appellate court and anticipate that this might be a case we lose in the trial court and want to appeal, then we have to make sure we bring a motion to dismiss based on the fact that the complaint does not comply with Rule 2606 of the Code of Civil Procedure. It's not reasonable to require us to bring these motions to dismiss in every single case. I have myself tried to get this issue up to the appellate court on an interlocutory appeal, and I have had the trial court say, yes, this is an issue that should go up to the appellate court and certify the question. But as you know, such appeals must, and I'm quoting now from Supreme Court Rule 308, materially advance the ultimate termination of litigation. Reviewing a trial court's ruling on a motion to dismiss will not hasten the end of litigation in a summary proceeding like an eviction action, so we cannot reasonably expect the appellate court to reach this issue. The best way to resolve it, therefore, is through the adoption of this proposed rule. Finally, landlords advocates will argue that the Eviction Act simply requires the landlord to allege in its eviction complaint that the defendant unlawfully withholds possession of the premises to which the plaintiff has a superior right of possession. But that requirement addresses only the sufficiency of the complaint's allegations. It does not relieve plaintiff in an eviction action of its duty to comply with Rule 2606 of the Illinois Code of Civil Procedure, which every civil plaintiff has to follow. And they follow it by attaching to the complaint the written instruments upon which the pleading is based. As I said, the question of attachments has caused needless confusion in the eviction courts. The proposed rule clarifies the issue and it makes sense. Legal Aid Chicago therefore urges its adoption. Also, we urge that it be adopted immediately because, as Judge Ortiz and Samira and Pat mentioned already, we are about to face a flood of eviction cases because the eviction moratorium that's been in place for a few months is about to be lifted. It is not only important to adopt this rule, but to adopt it as quickly as possible. Thank you for your consideration in listening to my comments, and I'm happy to take questions.
Are there any questions? I just want you to understand, my concern is when you're asking for the adoption of an entirely new rule that, we have to ensure, the fairness doctrine, that it is fair to both sides. And that's, that was the point of my question. I hope you understand that.
Oh, I absolutely do. And I think it's important. And I think, again, landlords advocates, I'm sure would disagree with me, but I think that I have fairly set forth their main objections to the rule and then tried to address those objections. Also, I would say this is not really the adoption of a new rule in one sense. The rule already exists. It's already section 2-606 of the Illinois Code of Civil Procedure. The rule that we're supporting merely clarifies the fact that plaintiffs in eviction action must, like all other civil plaintiffs, comply with this rule, the Illinois Code of Civil Procedure, that is already on the books.
Do any members of the committee have any questions for Mr. Wood or any of the other members of speaking on 2007 that are still on? Well, congratulations to those who have stayed on the call the whole day. Thank you very much. Appreciate your patience. This is our first, Zoom public hearing for the Illinois Supreme Court Rules Committee, and I think it's gone pretty well after we got over that initial glitch. Thank you for participating, everybody. Have a good day, and hopefully you'll be hearing from us very soon. Amy, would you mind jumping back on? Thank you, everyone.
Sure.
All right. Now, what